May I please our chief? Upon instruction, I beg to pay for withdrawal.
Yes, sir.
As Ali.
As Ali, learned counsel for the applicant, submits that he has the instruction to withdraw this petition. Accordingly, this AB number so and so stands to dispose of on withdrawal.
I am obliged, chief.
Item 43 for withdrawal. May please.
You want to withdraw this
Yes.
petition?
Okay.
Same order.
Obliged. Because promotion, item 1.
May I please, Lord? My lord, this is regular bail application, my lord. I am behind the bar since 27 days.
For
27 days.
27.
My lord, FIR is at page number 9.
What is the offense?
My lord, offense under 305A. 2 numbers of cows were stolen by someone, my lord. My lord, kindly for a moment, page number 15, my lord.
Page number?
15, my lord. Middle of the, my lord. Middle portion, my lord. Brief of the case. Next, my lord. During the course of investigation, 10 stolen cows were recovered from the house of accused Fulbor Ali, while 2 stolen cows were recovered and seized from the possession of accused Hoyur Rahman. Subsequently, the accused Fulbor Ali was apprehended, interrogated, and his statement was recorded. During interrogation, he admits his involvement in the theft of the complainant's cows as well as several other stolen cattle. He further disclosed that Sohar Ali and Nuramin used to steal cattle from various places and kept them at his house. Hoyur Rahman used to sell the stolen cattle in different markets, and Ziarul Islam was also actively involved in the involvement of the accused persons in offences under investigation. So, my lord, the cattle have already been recovered, my lord. So, further custodial detention may not be required at any condition, my lord. I may be allowed to go on bail, my lord. I am
No,
not actively,
we'll peruse the case diary.
my lord, kindly have a short.
We'll see your involvement. Case diary on?
From Borpeta, my lord. Kindly have.
Sorted. 12.
Highly obliged.
Come to.
My lord, I have been in jail since 18 July for an allegation, my lord, which in my opinion is
18
not an
July.
offense at all, my lord. Kindly see for a moment, page, para 5, my lord. Para 5 of my petition.
What is the allegation against you?
My lord, kindly see for a moment, page 3, para 5, my lord. It is nothing a theft, nothing. I am the owner of a single cow, my lord. That original document I have.
What is the allegation in the FIR?
Allegation, my lord, the police found information that some cattle were gathered in a place, my lord. Accordingly, police visited the place and arrested 4 persons with 7 cows, my lord. Out of 7, 5 were bullocks, and 4 persons were arrested. I am the number 4 accused. I am saying that I am the owner of 1 cow, 1 bullock, which I have purchased from a registered cattle market. That document I have annexed, my lord. So only for that of us, nobody filed any complaint that I have thus owner of a single cow, my lord. That I have documented. So how this cattle was stolen, my lord? How this allegation inflicted upon me, my lord? And have been in jail since
Okay.
18 July.
CD on Tuesday.
Yes.
CD on Tuesday.
Item 3.
May it please, your lordship. 439 application, my lord.
I will have to inform.
Yes, most are going to inform court.
After some time. Who will appear?
So inform court এটাকে মই আৰম্ভ কৰো।
Yes, next item.
Item 4,
May previous your lordship. It's a regular bail application, your lordship. The petitioner was arrested on 27/7/2026, your lordship. In this case, apart from the merits of the case, your lordship, I am taking the plea of non-compliance of section 35(5) of the BNFS, your lordship. Lordship, the FIR is on page number 16, your
When
lordship.
you have been arrested?
He was arrested on 27/7, your lordship. from his house.
27/7.
Lordship, the allegation, may I read the FIR, your lordship?
27/7.
7, your lordship.
Okay.
Uh,
Then what are the allegation?
Allegation is that he was operating a online account in the Binance platform using cryptocurrency, your lordship. That is not an using of cryptocurrency is not an offense in India, your lordship. But no complaint has been lodged against him by any person and no FIR is pending against him, your lordship. The offense is also of April 2024 to 2025, your lordship. The allegations is under section 318, 316 and 61(2) of BNS, read with section 66(d) of IP Act. Your lordship, in all these offenses, punishment is below 7 years. So it is the mandatory provision of law, your lordship. Lordship notes from Anis Kumar and in Surendra Kumar.
Where is the forwarding report?
Forwarding report is on page number page 21, your
21.
lordship. Lordship will kindly peruse page number 24. There is the note, your lordship. In the note, it is written that due to the nature of the offense, there was a high likelihood that the accused person might abscond and or destroy crucial electronic evidence if served with notice under section 35(3) BNSS prior to apprehension. Further, the accused persons are found actively engaged in the commission of cognizable offense at the spot, necessitating immediate apprehension to prevent continuation of the illegal activity. Serving notice at this stage would have hampered effective investigation and enforcement action. Hence, in the interest of a fair and effective investigation, notice under 35(3) BNSS would not be served at time. Also, these are mechanical ground, your lordship. No objective satisfaction has been given, your lordship. Why arrest could not be avoided, your lordship? Why arrest is necessitated? There is no compliance of
No,
section
some grounds are definitely there.
lordship. But these are mechanical ground, your lordship does not disclose any
How mechanical? How these grounds are mechanical?
lordship, the offense pertains to April 2024 to 25, your lordship. And it involves in the computer related offense. It is a computer related offense, your lordship. Everything is on the internet, your lordship. His mobile is seized. If he would have the
On what basis you are submitting that the period of offense pertains to the 24 and 25?
lordship, as per the FIR, your lordship, page number 16. May I read the FIR, lordship?
No, not necessary.
Page number 16, second para. On being questioned, the suspect, namely Bodiul Islam, stated that he has been operating an account on the Binance online financial platform since April 2024 to March 2025. No complaint is pending against him, your lordship. If he had committed any offense during that period, some FIR should have been lodged against him, some complaints should have been lodged against him. Only on suspicion on that day, the
Okay,
FIR of
okay.
the Howli police station.
Mr. Borthakur,
Yes.
so the direction issued in the Ernest Kumar, can it be said to be complied with by this note written by the IO?
Yes, sir. Here in this case, my lord, here some information comes to case, my lord. Is not.
No, whether this explanation will be sufficient.
Yes, sir, because these are, why I am pointing out, due to the nature of the offenses, there was a high likelihood that the accused persons might have shown or destroyed crucial electronic evidence. Here, these are my lord, yes, my lord, cyber related, my lord, financial fraud. Here, my lord, electronic evidence.
No, that's all right. You see, the period of offense is 24 and 25.
No, my lord, he was operating that platform, the financial platform from April 24 to March 25. That is, he has run that Binex platform, my lord, that was financial platform from 25. That is one simple, one part of the allegation.
Hmm.
He was, my lord, running that platform from 24 to 25.
No, you say in the Ernest Kumar, Ernest Kumar's case, it has been held that the satisfaction has to be recorded by the IO.
Here, your lordship may kindly, I will, put your lordship may kindly fix it on Tuesday or Monday, my lord. On that day, my lord, I will satisfy along with CD also. And here, my lord, this order, your lordship may kindly come, your lordship may satisfaction. This is not that simply the trial court has also, my lord, after perusing, your lordship may kindly.
Although trial court has recorded its satisfaction, it may not be sufficient because the arrest itself is illegal when the direction is not complied with.
See, I will again read, my lord, note, my lord, of the IO in the forwarding report, my lord. Due to the nature of the offense, there was high likelihood that the accused persons might abscond and or destroy crucial electronic evidence if served with notice under section 35(3) BNS prior to apprehension. So, my lord, prior to apprehension, my lord, if notice served, then electronic evidence might be, my lord, destroyed, my lord, by the accused. Further, the accused persons were found, here, my lord, some detail, my lord. Further, the accused persons were found actively engaged in the commission of cognizable offences at the spot. Well, it is not that, my lord, there was no satisfaction, but on spot, necessitating immediate apprehension to prevent continuation of the illegal activity. So he was in the spot, and therefore to prevent, my lord, any further commission of the offense, he has to be, my lord, arrested, my lord, to prevent any commission of any further offense.
Okay, let us fix the matter tomorrow.
So I have another submission also regarding this section 66D. 66D of the IP Act. Your lordship will kindly take up the IP Act.
Yes, all right.
As per section 81 of the IP Act,
Mm.
and the provisions of the IP Act will override other sections of the law, your lordship.
Mm.
So this is reiterated by the Honorable Apex Court in this Sarath Babu Digamurthy's case, your lordship.
Mm.
And lordship knows that I am submitting it. Paragraph lordship 37.
Mm.
There is no conflict between the statutory here, my lord.
Lordship,
Provision of, my lord.
lordship, as the matter pertains to computer-related offense, your lordship,
Mm.
everything is on the net and it is covered by the IP Act. So sections of the IPC, now the BNSS may not be required.
Which paragraph you were relying of? 37.
Oh, I think we know.
Okay, let us fix the matter tomorrow. Let him come.
Monday, I have to go through both the decisions, my lord.
Lordship,
And if
may I read section, the para 37, your
No,
lordship,
not
that
necessary. We'll see.
para 37.
Let him produce or whatever materials he has. We'll see.
my lord, may I call the CD?
Lordship,
Not
it-
necessary, CD. We are on this point only. Tomorrow?
Monday would be.
No. If the detention is illegal, then we have to enlarge him on bail
Judgment also, your lordship, I can give him.
tomorrow at 2 p.m. Let's establish the matter tomorrow for further consideration.
Oblige, your lordship.
May I please, Your Worship? Your Worship, I have filed the revision applications against the order of the appellate court, Your Worship. The fact in this case, Your Worship, that a domestic violence proceeding was initiated by the wife, Your Worships, and the main allegation in this, Your Worships, regarding one physical assault and another, Your Worship, electoral relation, Your Worships. Page 18 is the, Your Lordships, the application under section 12 of the Protection of Women from Domestic Violence. And in this, Your Lordships, one para I want to read, Your Lordships. Please 18, Your Lordship, page 18. Hi.
18. Yes.
Your Lordship. After marriage, the petitioner respondents 18 Europe para 2 were staying together at the matrimonial home at Dukhamukh, Bhayalu, Gaon, POPS, Gauri Sagar, district Sibsagar, Assam. At time marriage, the petitioner and respondents were working as a assistant teacher, ME school. Both are having their graduations. Your Lordship, so both the petitioner and the respondent, wife and husband, all are the government servants and working in the ME school, Your Lordship. Now, Your Lordship, I come to
Hmm.
regarding the domestic violence, Your Lordship. Again, the same set of Your Lordship allegation, Your Lordship, that I have illicit relations with my cousins and there is a Your Lordship result.
No, that's all right. We are not hearing the matter on merit. Today
Yeah.
it is in the motion column.
Your
Let
Lordship.
notice go at this.
Your Lordship, in the meantime, Your Lordship, I want to stay, Your Lordship, because regarding the there is a three part of the relief granted. Your section 18 relief. Thereafter, Your Lordship, section 19, Your Lordship, the residential part, Your Lordship, and thereafter 22, Your Lordship, regarding the compensation, Your Lordship. So regarding residential, Your Lordship, and the learned trial court as well as learned appellate court, Your Lordship, refused to give maintenance under section 22 because she is a government servant. But learned trial court has granted her the residential Your Lordship reliefs under section 19, Your Lordship.
So what wrong with that?
Your Lordship, if she is a government servant, Your Lordship, she cannot take twice, Your Lordship. The government has also providing her the residential, Your Lordship, allowance. If she is getting residential allowance from the government, Your Lordship, whether I am entitled to give her. And she is a government servant, Your Lordship, admitted position, Your Lordship. So this part, Your Lordship, at least.
No, where is the material to show that she has received the residential allowance?
Your Lordship, she is a government servant, Your Lordship. Automatically she will get.
No,
this. And moreover, Your Lordship, regarding
you
this,
have
I
to-
want to draw, Your Lordship, section 19(6), Your Lordship. Section 19(6) of the Domestic Violence Act, Your Lordship. Only one part, Your Lordship.
We'll see. We'll consider your pair after receiving the record from the court below.
Your Lordship, I only want to.
Today only notice will go.
I want to read one part only, Your Lordship.
And what is the amount she has been receiving as a house?
3,000, Your Lordship.
3,000.
Your Lordship. Your Lordship, section 19.
And what is the document to substantiate the same?
Your Lordship.
Where is the document to substantiate the same?
Your Lordship, this order was given by the trial court, and this is upheld by the appellate court, Your Lordship. Regarding the granting of this, Your Lordship,
she has been receiving a sum of rupees 3,000. Where is the document?
she is a government servant, she admitted, Your Lordship.
Maybe.
So, Your Lordship, if she is a government servant, automatically, Your Lordship, she will get all the allowances.
Where she has been residing?
Now she is residing in his parental house. He deserted me and she is residing in the parent house, Your Lordship.
You are referring to subsection?
19(6), Your Lordship. While making an order under subsection 1, the magistrate may impose on the respondent obligation relating to discharge of rent and other payments, having regard to the financial need and resources of the party, Your Lordship.
Okay, we'll see.
Your Lordship, the resources of the party means he is the government servant. He has a
No,
sufficient earning.
right now you have no document to show that she has been receiving a sum of rupees 3,000, being the house rent allowance. Heard Mr. Enenja, learned counsel for the petitioner. In this petition under section 438, stroke 442, read with section 528 of the BNSS 2023, the petitioner has challenged the judgment and order dated 29/5/2024 passed by the learned additional session judge Sibsagar in criminal appeal number 32, it will make it 3 of 2019. Notably, by the impugned judgment and order dated so and so, learned additional session judge was placed to dismiss the appeal filed by the petitioner against the order dated 2nd of April 2019, passed by the learned judicial magistrate first class Sibsagar in Miss Domestic Violence case number 01 of 2015 under section 12 of the Protection of Women from Domestic Violence Act 2005. Whereas the petition and the documents placed on record, let notice be issued to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Rest is a call for the record from the learned courts below. Interim pair of the petitioner will be considered on next date on receipt of record from the learned courts below.
Your
List
Lordship,
of the four-
date may be fixed, Your Lordship. Date may be fixed.
Pardon?
Date.
September.
Much obliged, Your Lordship.
Item number 44.
My lord, the matter may kindly be passed over for the time being, my lord. For the time being.
Who will appear?
Lord, Mr. NJ Datta will appear.
Let the city come.
My lord, maybe kindly for the timing, not because he would like to make some submission. Because there are some petitioners who are also student, my lord.
There are some.
Petition number 4 and 5 are students, my lord. The one is pursuing, my lord, medical course at GMCH, my lord, and other is pursuing MA, my lord. They have also been arraigned,
But the offense is serious.
my lord. Of course, my lord. Obliged.
May I please, Your Lordship? Lordship, this is a criminal revision petition, my lord. The petitioner has approached this honorable court challenging the order dated 11/5/2026
Hmm.
passed by the learned special judge Sri Bhumi in special parts case number 03/2025,
Hmm.
rejected his prayer for custody of his seized Mahindra Scorpio vehicle bearing registration number AS10G3170, my lord.
That's টেবিল উপর একটা অর্ডারটা আছে
My lord. The petitioner is.
Yes, so where is the Zim, where is the
FIR is
is there-
page number 30, my lord.
page number?
Page 29.
29, my lord. My lord, vehicle is lying in the premises of the police station. It's more than 1 year, my lord. The main accused also arrested, they are released on bail, and other accused also get interim anticipatory bail, my lord.
What are the offenses?
Offenses is especially, my lord, bar sec is there, my lord, 21, section
Hmm.
21, my lord.
Hmm.
In name of running a fraudulent investment scheme, my lord, they collect huge amount of money. from the
Yes, my lord, it is absolutely true, my lord, but there is no specific allegation that I have collected this said money, my lord.
Hmm.
As per allegation,
Why the vehicle was seized?
vehicle was seized, my lord. Seizure list is there 22 page number, my lord. Page number 22, my lord. 8/4/2025, my lord.
Seizure list is at page number
22, my lord.
22.
And my lord, there is another case, that is Badurpur PS case number 44/2025.
Hmm.
Same cause of action is there, my lord. Here, accused number 4 approached this honorable court,
Hmm.
and hereby the earlier order was set aside, which was passed by the learned special judge Sri Bhumi, my lord. I have in
Okay,
copy, my
that is
lord.
in a different case.
No, my lord, same cause of action, my lord.
Different case.
No, my lord, same cause of action. Here, Bardsec also there, my lord.
No.
Same allegation. Yes, my lord, it is a different
is
case. My lord.
different.
Yes, my lord.
Okay, let him produce a report. Art Minister, your name please?
A Islam, my lord.
Learned counsel for the petitioner. And Mr. Borthakur, learned additional PP for the state respondent. In this petition under Section 442, read with Section 438 of the BNSS 2023, the petitioner has challenged the order dated 11/5/2026 passed by the learned special judge, within bracket FTC, Sri Bhumi in special, within bracket BATS, case number 03 of 2025, arising out of Bodorpur PS case number 48 of 2025. It is to be noted here that by the impugned order dated so the learned trial court has rejected the petition filed by the petitioner seeking custody of a seized vehicle bearing registration number
AS10G,
AS103
10G, my lord. G,
10G
G, yes, my lord. 3170,
3170,
yes, my lord.
which was seized from the possession of the accused by the investigating officer. On which date it was seized?
It was seized, my lord, on 8/4/2025, my lord.
8/4/2025. After hearing learned counsel for both the parties, it is provided that Mr. Borthakur shall obtain a report regarding the present status of investigation and also as to whether the vehicle will be required for further investigation or not, fixing the matter on.
On 19, my lord. On 19.
Sorted. Service.
70. Highly obliged, my lord.
I don't know what age.
May I please your lordship?
Yes.
But I am challenging the charge frame against me under section 6 of the POCSO Act. What happened, my lord? I take your lordship to FIR at page 17. A case was registered against me.
No, Mr. Biswas,
Yes, ma'am.
let notice go at this stage.
Yes, yes.
Notice to the informant.
Exactly, it is required, madam.
Third, Mr. Biswas, learned counsel for the petitioner and.
Madam,
Mr.
scan copy also may be called for, madam. Scan
Okay,
copy.
okay. And also heard Mr. Borthakur learned additional PP for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has challenged the.
Executive session just special. POCSO.
No, Mr. Biswas, here
Yes.
you are praying for quashing the entire proceedings.
Yes, my lord. Because I am the lone accused. What happened, my lord? DNA report was come and DNA report was not against me. It is they specifically mentioned that blood sample is similar with the mother, but not with the accused, my lord.
Okay. For quashing the special POCSO case number 122 of 2025 pending before the court of learned special judge POCSO Kasar Silsor, arising out of FIR of Lakipur PS case number 128 of 2025 under section 65 within bracket 1, 351 within bracket 2 of BNS, read with section 6 of the POCSO Act, and also for quashing the charge sheet number 134/2025. Let notice be issued to the respondents returnable on or after 4 weeks. Take upon respondent number 2 be taken
Too
by
long, my
speed
lord,
post and
sir.
also by usual
May I
process.
pray for earlier? Because
Wait
it
from
has been
today.
fixed on 12/8.
However, no formal notice is required to be issued to the respondent number 1 since Mr. Borthakur entered appearance and received notice. No, step be taken for the office of the PP. Gauhati High Court. Registrar shall call for the scanned copy of the record fixing
From
the matter
special just POCSO
on-
Kasar Silchar.
on 7 September. Interim period of the petitioner will be considered on receipt of record
Right.
from the learned trial court.
Item 10.
Lordship. This matter regarding watching of 498A matter, Lordship. Already dispute between the parties have amicably will settled. So I am annexing the annexer B at page 17, the settlement document.
Annexer B.
Annexer B, page 17.
So just recess and let notice go.
Lordship.
Let notice go.
And let notice before.
Heard Mr. Kakoti,
Ji Kakoti.
learned counsel for the petitioner. Mr. Bortakur for the respondent. In this petition, under section 528 of the BNSS 2023, the petitioner has tried for quashing the FIR dated 12/11/2022, upon which Gokhaigaon PS case number 23 of 2022 under section 498A IPC has been registered, and also for causing the entire consequential criminal trial arising out of the aforementioned FIR corresponding to PRC case number 207 of 2022, pending before the Court of Learned Subdivisional Judicial Magistrate M. Gokhaigaon, Kokrajhar. Learned counsel for the petitioner submits that the petitioner and respondent number 2 are husband and wife, and they have settled the dispute and also amicably, and also executed one deed of settlement / memorandum of understanding, and on the strength of the said deed of settlement / memorandum of understanding, the petitioner has approached this court for causing the entire proceeding of the PRC case number so and so under section 766. Let notice be issued to the respondent returnable in 4 weeks. Stake upon respondent number 2 be taken by speed post and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1 since Mr. Bortakur entered appearance and received notice. Recessal call for the scanned copy of the record from the learned trial court. Is there any interim pair?
Interim pay is there, Lordship.
And in view of the submission of learned counsel for the petitioner, and also considering the fact that the parties have settled the dispute amicably by entering into a deed of settlement / memorandum of understanding, this court is inclined to stay further proceeding of PSC case number so and so till disposal of this petition.
May I please, Your Lordship. But in this case, I have come again without annexure 10, page number 122 order. So this order come to be passed without in a criminal appeal.
Page number
Page number 120, my lord.
120.
So the appeal was arising out of my lord, a DB case, my lord. The petitioner submitted one petition before the learned trial court, my lord, on 27/6/2025. That was rejected, my lord. So against the rejection, my lord, the petitioner approached the criminal learned sessions court, my lord, Gauhati. So the appeal was admitted, my lord, and interim was also granted. But the fact is that, my lord, there was some area of interim maintenance, my lord, So in the, while granting the interim stay, my lord, the observation of the court was that, my lord, I have to clear the, my lord, area of the interim, my lord. And the first installment was made within the first month of the passing of the order, my lord. So that, my lord, I could not, because, my lord, in the meantime, I met with an accident, my lord. I also, my lord, have submitted the medical documents, my lord, that on account of my accident, my lord, I could not comply to the, my lord, direction with regard to the payment, my lord. So on that account, my lord, the learned appellate court refused to decide the, my lord, the appeal on merit, and that, my lord, also, my lord, the interim that was granted earlier, that was rejected. So the interim order that your lordship will find at page number, my lord,
So the appeal is still pending there.
my lord, pending.
Okay.
So my grievance is that, my lord, in the petition which I filed before the learned trial court, my lord, your lordship will find at page number, my lord, 35. That was the petition I submitted before the learned trial court. And thereby I brought on some documents, my lord, which would go to show that, my lord, there is a change in the circumstances. And that your lordship knows, my lord, that section 25(2) of the Domestic Violence Act 2005, my lord, it provides for alteration or modification of some order if there is a change of circumstances in during the pendency of the case, my lord. So by bringing those documents on record by that particular petition, my lord,
Now, what amount is due to be paid by you?
my lord, in fact, my lord, I have made some payment. Exact calculation that I have not done, my lord, but I'm making some payment.
Approximately.
Well, approximately, it would be more than, my lord, 1,50,000, my lord.
1,50,000.
Approximately, my lord, because, my lord, earlier that order was put under silence, my lord, in an appeal that was dismissed. Then the petitioner
And
came.
you are paying the monthly amount?
My lord, now I am paying, my lord. Now I am paying.
What is the amount, monthly amount?
Monthly amount was 3,000, my lord.
3,000.
It was 3,000. That the area was there, and even the, my lord, the impugn order also reflects, my lord. For a moment, if your lordship is pleased to peruse page number 120, that, my lord, the landed counsel for the respondent has submitted that on only an amount of rupees 7,500 has been paid and substantial amount is still pending. So since, my lord, the 6/3/2026, I am paying here, my lord, in the trial court, before the trial court. 5,000, 3,000, 2,000 as a, because in the meantime I met with an accident, I cannot work now, my lord, and I am a wage earner, my lord. Therefore, I could not comply to the order. So my grievance is that, my lord, while the, my lord, the appellate court admitted my appeal, granted with an stay, my lord, and that day I could not comply to the direction because, my lord, in the meantime I met with an accident. I have also, this is also reflected in the order itself, my lord. And that I submitted all the medical documents before the learned, both the appellate court as well as the
No,
trial.
no, whether in your application before the appellate court,
My lord,
you have enclosed the medical document?
my lord, I enclosed, my lord.
Where is that application?
My lord, your lordship will find that, my lord, even the order dated 22.
No, I am asking you about the application filed by you before the appellate court.
My lord,
Where is that application?
that application, my lord. In fact, the petition, my lord, which I filed before the, I'm sorry, my lord, that the particular petition is not there, but the application I submitted before the trial court. So that order is there and that petition is also there.
No, the application filed by you before the learned appellate court,
My lord,
highlighting the change of circumstances in your favor.
my lord, my lord,
That application is required.
my lord.
If it is not available today, you bring it on record by filing additional
My lord,
affidavit.
my lord, I can.
Will grant you 1 week time.
My lord, my lord.
Heard, Mr.
Yeah, my lord.
Learned counsel for the applicant. This application under section 428, 442 of PNSS 2023. Read with Article 227 of the Constitution of India. The petitioner has challenged the order dated 6/3/2026 passed by the learned session Judge Kamrup Aminggaon, and also all subsequent orders passed by the learned session judge in criminal appeal number 18 of 2025. Mr. Ali, learned counsel for the petitioner, submits that the petitioner has filed one application before the learned appellate court highlighting the change of circumstances in his favor and also for modifying the order dated,
My lord,
modifying the order of the trial court dated.
my lord,
Where is that order?
my lord, your lordship will find at page number, my lord, page number 48, my lord,
48.
my lord.
27/6/2025. But the learned appellate court has dismissed the pair. Mr. Ali further submits that the said application is not enclosed with the present application. And he prays for some time to bring the same on record by filing an additional affidavit, pair allowed. List the matter in the next week on
My lord,
which Mr. Ali shall bring on record the application filed before the learned appellate court by filing an additional affidavit.
my lord. I am obliged, my lord.
Very good. My lord, in this case, my lord, this relates to the act, my lord, but I have cleared the entire debt. But despite, even before taking cognizance of the court, by court, that is why, but your lordship may kindly come to page 25, my lord. Actually, my husband entered into a tenancy agreement. Your lordship may kindly come to page 25. This is the tenancy agreement that was entered into by my husband. And both the addresses were shown to be in Gauhati. The first entry and the second one and the property is also situated in Gauhati. In relation to this tenancy agreement, there was some area rent for which I, on behalf of my husband, issued a check that was bounced, and therefore this NI case, NI 7 of 2025 was filed by the complainant. In that case, even before taking cognizance of the court by the court, I have cleared the entire debt. And the proof is that, my lord, your lordship may kindly come to page 50. 50, 51, 52, and 53. These are the payment transactions where it was specifically mentioned, my lord. Your lordship may kindly come to this one remarks portion, my lord, in the middle of the, your lordship, find it, my lord. In the middle portion, my lord, remarks against Union Bank check number 122,913, my lord. Same way, the entire that was cleared.
What was the amount?
1 lakh, my lord. And if there are 4 transactions, the total amount comes to 1 lakh, my lord. The entire amount was cleared, my lord. And these payment receipts were also submitted before the trial court by way of petition, my lord. Please the page 54.
No,
my lord.
whether the payment, subsequent payment will absolve you from the offense?
My lord. Well, there is a Sanjeev Tari case, where it says that the entire, if the entire amount is cleared, it may be compounded, my lord.
Then?
If it is not compounded, then it may be, my lord, as a direction.
No,
So-
that's all right. Whether the other party has acknowledged the same
My lord,
receipt of
the
the
issue
amount.
is that, my lord, they have acknowledged the receipt of the payment of 1 lakh, but now they are saying, verbally saying that, no, this is this payment is with regard to something else. This is the issue. And that is why on 311, your lordship may kindly come to page.
No, unless the other party agreed, then
No, they have agreed the receipt of the amount, but they have said that this payment is with regard to something else. Whereas there is nothing else in their petition, my lord, in the complaint case.
let notice go, we will hear the other side.
Well, in the interim, my lord, I may protect that. The next date is on tomorrow for appearance, my lord. So the entire, my humble submission praise, it may be stayed, my lord. And moreover, my lord, your lordship may kindly say,
Let the record come, we will see.
my lord, in the interim, I may protect you, my lord.
Hmm. And what is this? The trial is pending,
It's a appearance, this one,
appearance.
appearance, my lord. But
You
initially, my
file an
lord,
application there that
Madam?
quashing petition is pending before this court.
my lord,
You file an application there for adjournment,
my lord, I have filed a petition there.
then file a petition for adjournment.
There, yes, my lord. I have,
Heard, Mr.
B. Buragwan.
Learned Counsel for the petitioner. In this petition under section 528 of the BNSS 2023, the petitioner has tried for causing the entire proceeding of NICR case number 07 of 2025 pending before the Court of Learned Additional Chief Judicial Magistrate Bohaigaon. And also challenge the order dated 3rd of 11/2025
And 22/5.
by which the learned trial court has taken cognizance of the NICR case number 07 of 2025 and also the impugned order dated 22nd of May 2026 rejecting the petition under section 147 of the NI Act filed by the petitioner. Here is the petition and the documents placed on record and also peruse the impugned order dated 3/11/2025, 22nd May 2025. Let notice be issued to the respondents returnable in for which step be taken by speed post and also by usual process within a week from today. Shall call for the scanned copy of the record from the learned trial court. List the matter on. Accepted.
Well, in the
10th
interim,
of
my lord,
September. Interim pair of the petitioner will be considered on next date.
my lord, tomorrow is the next date, my lord. So that is why I'm praying, my lord. And the case they
No,
filed.
tomorrow you file an application there
My
for adjournment.
lord.
Standing item 3.
Take it up for 8 weeks.
May it please your lordship.
Mr. Anand,
Yes,
is this case related to that Jubin Garg case?
my lord.
Jubin Garg case?
Yes,
But Mr. Anand, due to some personal difficulties,
No
I'm
issues,
not
my
able
lord.
to.
I leave it to your lordship, my lord. Let it be listed tomorrow
List
because.
this matter before another bench would have.
Tomorrow, my lord. Let it be tomorrow, my lord. Listing is a headache, my lord. Your lordship knows so much of matter, and a lady has been there. Absolutely no case, my lord.
Okay, tomorrow.
Tomorrow, deeply obliged for that, my lord.
Item 1 of production list.
This matter I have applied for the certified copies, my lord. I am likely to get it, my lord. Can it
Today?
be today?
Okay, at 2 p.m.
At my lord, 3, my lord. if
Oh,
possible.
okay, all right.
My
no
lord,
problem.
my
Huh?
lord.
All right.
Item 4. Orders. Item number 30.
Please, you.
My lord,
Yes.
as per office note dated 2026,
Mm.
the reply has been submitted by the trial court, where it says that there is no any record from exhibit 30 to 59. But my lord, I beg to mention that kindly show the trial court record. Trial court record, second page. They have given one index at the time of the submitting the trial court record. In that index, there is no any documents from the exhibit 30 to 59.
Then how it can be mentioned in the judgment?
Yes, in the judgment also the exhibit was available. Probably there may be misplaced the documents in somewhere. So reminder may be given again.
Pardon?
A reminder may be given to the trial court by giving some long time. My lord, kindly see in the page number 53 in the trial court record, page number 53. Page number 53. Just last page of the judgment. There is mentioned, my lord, exhibit 1 to 60 is submitted by the claimant side. There is also mentioned.
So, in this appeal, your pair is for enhancement.
For enhancement, my lord, basically we are challenging only on the ground that the person was uh, brain hemorrhage was he was brain hemorrhage, and as per disability and as per cross examination of the MO, the person was unable to perform his duty as earlier. So as per law, he has the loss of 100% disability of his income, but it was not considered and awarded
No,
only.
the problem is that unless the medical documents are available, how can it be considered? Do you have the disability certificate?
Yes, my lord. I have exhibited in the trial court, my lord. I have the copy as I.
And that disability certificate is also the part of the record from exhibit number?
Yeah, exhibit number 59, my lord.
Exhibit number 59. And that is not available on the record.
Yes, my lord. That is required, my lord. But my lord, I had taken the disability copy of certified copy and which was in my hand. But
Is it
that
a
copy,
certified copy?
just certified, I had taken the certified, but that original certified copy was handed over to the earlier advocate who was engaged in this case. So
Area?
first advocate who filed the appeal.
You
That-
collect the original certificate then? Original certified copy?
Original not Xerox. That certificate. is-
No, Xerox will not serve. You obtain the original certified copy.
So I have inquired about the documents of my earlier advocate, whether this document is available in his hand. He says there's nothing any documents is in his hand.
Then can we act upon your this certified, no, sorry, this Xerox copy of certified document?
So I have filed one petition before the medical board, from where we had obtained a disabled certificate. And they assured me within the next week, they will provide me the certified copy of disabled certificate. That documents I can provide, my lord.
Okay, you produce it then.
Yes, my lord.
As agreed by learned advocates of both sides, it is provided that recusal list the matter on after 15th of August,
My lord, can it be fixed on 24 August?
24 August.
Also, maybe reminder, maybe.
No, office note is that they have sent one mail indicating that no record is available with them. So from where they will send it?
24 August, my lord. Yes.
No, prior to that 21st.
21st August, 20 August, I have some matter.
Second, my lord.
22nd, then we have to release this matter from part third.
Okay, my lord. no,
Let's
no,
just
sir,
release
not
the
part,
matter on
not-
24th of August. And this matter stands released from being parted.
1944.
Wait, please, your lordship. First, the 482 application, my lord. Your lordship will find the FIR, my lord, at page 17, my lord. It starts from page 16, my lord. Wait, here. 17.
Page number?
Page number 17, my lord, 17, my lord.
Yes.
May I read, my lord? Informant respectful submission is that on last 28/5/26, informant daughter, namely Anjuma Begum, got married to accused number 1, Saidur Rahman, socially as per Shariat. After marriage, the accused number 1 took informant's daughter to his house and commenced conjugal life with her. After absolutely a very happy married life for 20 days, the accused number asked informant daughter to bring a dowry of rupees 3 lakhs on being induced as per ill advice of accused number 2, 3, 4, 5, and 6. Informant daughter requested the informant to pay said dowry amount of rupees 3 lakhs, or else she apprehended her conjugal life would perish. Later on, the informant went to the house of the accused person and expressed inability to pay the dowry amount as the informant is a poor man. Subsequently, the informant brought his daughter back home, and after coming to his house, the informant daughter told them about the physical and mental torture committed upon her conjointly by the accused person. After 4 days, the accused number 1 took informant daughter to his house, and all the accused person again conjointly assaulted informant's daughter mentally and physically in connection with the demand of the unpaid dowry. Informant daughter again intimated the informant over phone about such mental and physical assaults of the accused person. Informant daughter apprehended that if the informant fails to pay the said demanded dowry, then the accused person will kill informant's daughter. The informant and his family members advised her to bear the burden of her husband's house for protecting the sanctity and conjugal life, and expressing his inability to meet up the demand of dowry. The informant requested the accused person not to harass his daughter. It is just 2-3 days ago, informant daughter told his younger son so and so over phone that unless the dowry money is paid, the accused person has finally decided that they would kill the informant daughter. And where Ashibul Hussain consoled her that the informant would go to bring back to the informant house on Monday next. But the most unfortunate part of the matter is that yesterday, dated 28/6/26, the aforesaid accused person conjointly killed informant's daughter and hanged her on the ceiling fan, my lord. And this is the case, my lord. And the petitioners before your lordship is not the husband, my lord. The husband got arrested, my lord. Now, the petitioner before your lordship, my lord, the petitioner number 1 is the father-in-law, 2, 3, 4 is the brother-in-law, and 5 is sister-in-law, my lord. And the main accused, my lord, the husband, he has got arrested, my lord. I have annexed his forwarding report also, that your lordship will find at page 26, my lord.
Lordship may kindly the incident within a period of 1 week.
Yes.
28/5/2026, marriage solemnized, and my lord, incident occurred on 28/6/26. And during that period, my lord, what happened, how the accused person demanded dowry and torture. Ultimately, my lord, the allegation is that they conjointly, my lord, keep the informed.
Studies in Gauhati University, and 5, my lord,
Maybe,
he is pursuing, my lord, in medical college, my lord.
this is a serious offense.
At least 4 and 5, my lord,
Mhm.
if your lordship.
No.
I have annexed, my lord, page 75 and 76.
Only after perusing the case that we will consider the pair. Your name is there
No, my
in
lord.
the FIR?
In the FIR, my lord?
Yes, yes.
Named. Named in the FIR.
Heard Mr. Dr. Learned Counsel for the applicant, Mr. Borthakur learned additional fee for the state respondent, apprehending arrest in connection with Borpeta PS case number 231 of 2026 under section 80, which will make it 2 BNS 2023. This application under section 482 of the BNSS 2023 is preferred by 5 applicants, namely Ismail Hussain, Rafiqul Ali, alias Rafiqul Islam, Robial Ali, alias Robiul Hussain, Abdullah Ansari, alias Abdullah Ansari, Shahnaz, alias Mausumi Shahnaz, for grant of the privilege of respect. After hearing learned counsel for both the parties, perusal of the case diary is found to be necessary, and accordingly it is provided that Mr. Borthakur shall produce the case diary before this court on
14.
14.
I'm obliged.
33.
In this case, my lord, service is complete, my lord.
Awaited,
No, complete, my lord.
completed. Record received.
Report received, my lord. So,
Heard Mr. Gupta, learned counsel for the petitioner, no, for the appellant, and also heard Mr. S.S. Bora, learned additional PP for the state respondent. Ms. Bora submits that service upon the respondent number 2 is completed, and in support of her submission, she has produced one letter of the officer in search, Sangsop Sariali Police Station, dated 19/7/2026. Office note dated 28/7/2026 indicates that LCR has been received, TCR has been received. Accordingly, it is provided that SSL lists the matter for hearing. So no one appears for the respondent number 2. Amicus has to be appointed.
my lord, there is IA for bail, my lord. There is IA for bail, my lord. So lordship may list the IA, my lord.
At first, Lordship, may appoint a backup to it thereafter. I make it.
Sangita Soikia.
Sangita Saikya?
Sangita Soikia.
Saikya.
Is she regular?
Lordship, whether she is regular, Lordship.
Okay.
One key parasher is there, Lordship.
Oh,
Trisita Parasher.
no, she has already been engaged in some other matters.
Lordship. And then.
Yes, Das. Okay, Mr. Surajit Das
Yes, Lordship, he is also regular.
is appointed as amicus to represent the respondent number 2. SSL lists the matter for hearing on fixed date September.
My lord, there is IA for bail.
On that day, I will be considered. SSL reflect the name of amicus in the cause list and shall also furnish the relevant papers to him well in advance.
On 15 September.
Without hearing the other side, we cannot grant
No,
you.
lordship may fix it, but IA may come up for orders, my lord, because hearing it will come as the last item, my lord.
Together, it will be considered on that day. I will be considered on that day.
15th of September.
Short date is possible.
8 September.
Okay.
Item 34.
Wait, please, your lordship. Service is awaited for your service.
As per office Circular 4826, lordship, notice issued on respondent number 2, district magistrate, Nagaon.
I've taken steps long back on 36.
Is it a proxo matter?
Why to district magistrate, Nagaon, that
So it ought to have been through the office of the PP.
yes, right, as per direction of the Honorable Court.
So there is on a notification of the registry.
Yes, lordship.
Yes.
So you take step as per that notification.
District magistrate of 20%.
Put registry this.
Heard, Mr.
Yeah, three, your lordship.
Learned counsel for the petitioner. Office note dated 7/7/2026 indicates that notice was issued through the district magistrate to the respondent number 2, district magistrate Nagaon. But in view of the notification number 17 dated 15th of March 2024, step upon the informant ought to have been taken through the office of the public prosecutor, Gauhati High Court. The learned counsel for the petitioner is accordingly directed to take press step upon the respondent number 2 through the office of the public prosecutor, Gauhati High Court, within a period of 2 working days from today. Rest shall list the matter after 4 weeks.
Lordship, may-
4 weeks, okay?
First, initially, you have to give the notice of registry, then registry will send us to the PPO. After registry, yes.
Lordship may fix a date for it.
All right.
Published.
Of late.
May I please, Lord? My lord, in the instant criminal petition, my lord, petitioner impugning the my lord, final report accepting order as well as my lord, Zimmer granting order. Matter relates to a my lord, seizure of a my lord, pet dog. So before coming to that, lordship, by way of this, we are praying from vacating the my lord, interim order, my lord. Before coming to that, lordship, may I kindly have a look the FIR, my lord. Page, my lord, 28. 28 of the IA, my lord. Annexure 1. May I read, my lord?
Page number?
28 of the IA, my lord.
Mm.
FIR. This is to report a cruelty crime on a pet dog by the owner, my lord, applicant before your lordship of the IA, my lord. Owner at this address, house number so and so, Gauhati, eyewitness neighbors of the area has been complaining to various NGOs, including a Purpose Foundation, for rescuing the dog. The dog is kept in the balcony 24/7 and beaten up every day. The witness has sent a video on WhatsApp to us as evidence and a letter in written as well. As per PCA Act 1960, BNS so and so, this is a crime and we demand confiscation of the helpless dog and hand over to our NGO for a better future. From a NGO, this FIR has been filed, represented by the informant. Based on this FIR, the case has been registered under section 11(1)(a) of the Cruelty to Animals Act 1960.
Mm.
Seizure list, lordship may find, page 35. Page 35, lordship.
Mm.
Column number 6, description of seized articles. 1 number golden retriever pet dog, Prince. Note, due to insufficient space in Dispur police station, the living creature could not be kept at Dispur police station. So it is handed over to the NGO for well-being and also undertook a undertaking from them. These are the witnesses. And another seizure list regarding seized of the page 37. This seizure list, by way of the seizure list, seized one PVC wiring pipe, a plastic pipe, 1 feet long approx, by which alleged that pet dog was beaten up. This case was investigated
And accordingly, when the end of the investigation, final report has been submitted. And after final report, my lord, notice was served to the my lord informant. But that on request of my lord informant concerned, through WhatsApp, my lord, the notice of the my lord accepting of my lord final report was served. And accordingly, my lord, that final report was accepted. And thereafter, my lord, while the petitioner, applicant of the IML preferred Jimma petition, the Jimma of the pedagog was granted. Thereafter, they come back to the High Court, impugning the final report accepting order as well as the Jimma granting order. That was upon motion stated by this honorable court by passing an order. We are praying for vacating the same. After this sees the paid dog, Lordship petitioner was applicant of the I was preferred Jimma petition initially. That by way of the passing order dated 11/12/24, jurisdictional magistrate granted this said Jimma order initially state. That was page 40. Page 40, Lordship. Here 11/12/24, that is the order. Here I mentioned the IO report by the jurisdictional court below. The IO has submitted in his report that the one dog named Prince Golden Retriever
Page
has
number,
deceased.
page number?
Page 40.
40, my lord.
40 in the IA?
IA, Lordship. I am submitting from IA. my lord.
No, is the main petition is ready for hearing?
No. We are not with the case. PCR may be called for and then the matter be fixed for admission hearing also.
So is there any urgency in vacating the interim
Urgency
order?
regarding for this interim order, honor of the pet dog could not take the custody of the dog. Still, it is kept with the NGO. For this is this. Otherwise, as per law,
No, yeah, if it is handed over to you again, you may subject him to cruelty.
Lordship, cruelty that is alleged, but after investigation, there is no cruelty has been found, no sufficient witnesses are found. That's why the final report has been submitted. And now, technical ground they took that the notice has been served through electronic communication. So, section 70 and 530 of BNS, it is acceptable.
No, regarding this acceptance of final report.
Yes, my lordship. They come on that ground, my lord. That they have not received any notice from the court concern. That's why approach this honorable High Court.
What wrong with that?
Well, wrong is that notice has been served through the WhatsApp, through electronic communication, serving notice and summons. It is acceptable under the BNS as well. Lordship, honorable court is aware on that. As per section 70 and
Acceptable.
Lordship 530 of the BNSS.
Acceptable. There is one SOP perhaps.
Yes, also. Whatsoever not that this case also let the reports be called for. I mean, let the matter be fixed for admission hearing.
That may be well. Now we are praying to the
better,
authority of the dog.
We are unable to.
Better we should finally hear and dispose of the matter.
Yes,
My lord,
that
my
we
lord.
could also.
Lordship. Intention of the legislation is clear. Lordship, chapter 6 of the BNSS, section 64, there is a proviso, my lord. Regarding my lord, electronic communication. May I read, my lord? Section 64.
We'll hear you on that point at the time
My
of
lord.
final hearing of the matter.
Lordship.
Or Mr.
Here,
Roman, learned counsel for the applicant, Ms. S.S. Bora, learned additional PP for the state respondent number 1, state respondent. Opposite party, struck opposite party number 1, Mr. Bora for the respondent number 2. Respondent opposite party number 2. This interlocutory application is preferred by the applicant for vacating the order dated
2-3, my lord.
2nd of March 2026, passed by this court in criminal petition number 292 of 2026, filed by the present petitioner, present applicant. It is to be noted here that by order dated 2nd of March 2026, the order dated 21st of January 2026 and 18th of February 2026, passed by the learned special judge, first class, Kamrup M. Gauhati, in dispute PS case number 1256 of 2024, was stayed. Since all the parties are available before this court deem it appropriate to finally hear and dispose of this interlocutory application with criminal petition number 292 of 2026. The learned additional PP, however, submits that the record has not yet been called for. Accordingly, it is provided that recess shall call for the record from the learned from the Court of Learned Special Judicial Magistrate First Class Kamrup M. Gauhati pertaining to dispute PS case number 1256 of 2024, fixing the matter on fixed sorted. 26 August.
My lord, 20, another matter is there. Can it be after 22 or any other date?
21st.
Or 24? Okay, yes, ma'am. Obliged.
This is a POCSO, my lord. Behind the work for more than 4 months. More than 1 or 4 months he is behind the work. He was arrested on 28.
More than 4 months.
He was arrested on 28/3/2026. He was suspected, yes, sir.
When he was arrested?
On 28/3, 28 March.
At what stage the trial is pending?
My lord,
And
trial-
LCR is received.
LCR received, my lord,
LCR.
but it's there, my lord, but it is, my lord, it was received on 22/5, my lord. Just after framing of charge, my lord. Charge was framed on 21/5, my lord.
Charge was framed.
Oh, my lord, under section.
Whether any
64(1),
witness is examined?
my lord, that is not available in the record, my lord.
Not available on the record.
My lord. Charge framed on 21/5/26, my lord.
Section under section?
My lord, 64(1) of BNS and section 4 of POCSO. Section 4.
Mr. P. Sharma, learned additional PP for the state respondent. Mr. A. Gautam, learned amicus for the respondent number 2. You have anything to submit?
That's on the 183, that is incriminating materials. That,
Okay,
and evidence is being recorded with us, therefore.
okay. This application under section 483 of the BNSS 2023 is preferred by accused. Dinesh Mili alias Arjun Mili, who has been languishing in jail in connection with Pulibur PS case number 25 of 2026 under section 64 within bracket 2 within bracket M stroke 115 within bracket 2 stroke 351 within bracket 2 stroke 123 stroke 140 within bracket 1 stroke 126 BNS read with section 4 stroke 6 of the POCSO Act. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one Parag Mili. Put in bracket, actual name withheld on 27/3/2026. The allegation against the essence of allegation against the applicant and against the accused is that where is the FIR?
FIR is page 7.
That on 26/3/2026 at about 8 p.m. he committed sexual intercourse with the victim, namely Srimati X, of aged 17 years, under threat, and also by administering intoxicating substance to her. Mr. Khonikor submits that the accused was arrested on 28th of March 2026.
23.
28/3/2026. And since then, he has been languishing in jail for 4 months. He also submits that after completion of investigation, the investigating officer has filed charge sheet against the accused, and that the accused will appear before the learned trial court on each and every date and will face trial, and therefore he has contended to allow the petition. Per contra, Mr. B. Sharma, learned additional PP, submits that the accused is charged under section
64 subsection 1
64
BNS and
within
manual
bracket
section
1
4 PROCEED.
B
1
144
my lord.
stroke 144 and under section 4 of the POCSO Act.
Yeah, also.
Under section 64 subsection 1 my lord.
And 4 POCSO.
Two sections are there.
4 POCSO Act,
4 PROCEED.
on which date it was framed?
21/5.
On 21/5/2026. And the informant and the victims are yet to be examined. And if the accused is enlarged on bail at this instance, there is possibility of tampering the witnesses, and therefore he is contended to dismiss the petition. Mr. Gautam, learned amicus, has also subscribed the submission of Mr. Sharma, learned additional PP, and he also pointed it out that in the statement under section 183 of the BNSS 2023, the victim has clearly implicated the accused with the offense alleged in the FIR. Having heard the submission of learned counsel for both the parties, and this court has carefully gone to the petition and documents placed on record, and also perused the scanned copy of the record received from the learned trial court.
Lordship, I'm very sorry, Lordship. One thing I'd like to take it. Lordship, there is a witness in this case, Rani Mili. She is the prime witness, Lordship. She is the eyewitness in this case. The respondent is not an eyewitness. Rani Mili's statement, Lordship, the witness is not to be recorded. She's mentioned as the witness in the charge. Rani Mili was the girl who saw the accused person put the knife on the victim's throat. Saw the accused put the chocolate in the victim's mouth. And she's the one who has given the statement. The 183 is reflected, Your Lordship.
All right. I have mentioned about the 183.
Yeah.
One of the victim has not stated about
Victim is
administrating
implicated, Lordship.
victim and the another witness, namely
But Rani Mili, Lordship.
victim and another eyewitness also in their statement has implicated the accused with the offense alleged in the FIR. It appears that the offenses are serious in nature, and though investigation is completed and charge has been framed, the material witnesses are yet to be examined. And the apprehension, so expressed by Mr. Sarma, learned additional PP, and also by Mr. Gautam, learned amicus, cannot be ignored. And in that view of the matter, and also in view of the nature and gravity of the offense and the punishment prescribed for the same, this court is of the view that this is not a fit case where the prevail as a bail can be granted to the accused, and accordingly the petition is thus dismissed. However, liberty will remain with the petitioner to approach the learned trial court after completion of examination of the informant, victim, and the eyewitness.
Very good.
Item 19.
So, are we looking at, and in the event of
Yes,
filing
in
such an
19
application, the financial completer does same in accordance with. Yes.
In item 19 manner, service report completed in earlier occasion manner. Hereafter, Orindam Borua was appointed in amicus curiae manner. Hereafter, as per official manner, 4/8/2020, he has already resigned from the manner amicus curiae. As per this conference. Yeah, one another. 4/8 manner, official manner.
Heard Mr. Laskar, learned counsel for the accused, and also heard Mr. B. Sharma, learned additional PP for the state respondent. Mr. Sharma, referring to the office note dated 4/8/2026, submits that though one Orindam Borua was appointed as amicus, yet, as per said office note, he has resigned from the MPanel amicus curiae. And in that view of the matter, Mr. Sharma submits that another amicus may be appointed to represent the respondent number 2. This is Jasinder Singh. Jasinder Singh
Jaswinder Singh. Yes.
as amicus to represent the respondent number 2. SSL reflect the name of Jasing and Jasinder Singh in the cause list, and also furnish the relevant papers to him well in advance, and list the matter on
In short date, my lordship.
Monday or Tuesday. Ready with 13th.
Highly obliged, my lord. May it please your lordship. Lordship, this is a regular bail application here. This petitioner in jail custody for 103 days, lordship.
Service completed.
Charge sheeted case, lordship. The victim has,
Mr. Biswas, you are for respondent number 2. Okay.
lordship, we are FR on page 15, lordship. Victim has been,
TD was called for?
TCR is there.
Oh, TCR, Sarcitic.
Charge sheeted case.
Okay.
183 statement is there, lordship, and the victim evidence already I have annexed, lordship, that is there probably in the record.
Victim examine.
He has become hostile. By the here, I will have to go through the record by the here, we have received the report today, in the record manner.
You have not gone through the record.
Not manner, and also appeared manner.
Okay.
So otherwise, lordship, young boy and girl, lordship, the girl is 17 years and the boy is 20 years. Having love affairs, lordship, in 183 statements, she has deposed before the court, lordship. She has a relation. They eloped, then again came back.
Maybe, Mr. Soduri, you say the definition of child in the act.
But here, lordship, below 18, lordship. That,
Then?
But lordship, she become hostile. Maybe this is a pay for the
Maybe,
pave the
maybe
way
it's,
for bail lordship.
but
Plus they become hostile only because they are from two different community lordship.
maybe this court is not entitled to appreciate the evidence at the time of consideration of bail application. That is the problem. Okay, you go through the record. We'll list the matter on next Monday. Heard Mr. Sodhuri learned
Can you need your Tuesday lordship?
accused and Mr.
Monday.
B. Sharma learned additional
Monday,
PP for
Monday,
the
yes.
state respondent and Mr. Uh, Mr. Biswas for the respondent number 2. Mr. Sharma submits that he could not go through the record of the trial court, learned trial court, and he pressed for listing the matter on Monday.
I have sent the Okalasam yesterday, my name is not reflected. So.
Okay. Mr. Biswas submits that his name has not been reflected in the causal list, though he has filed the Okalatnama yesterday. Accordingly, rest is directed to reflect the name of Mr. Biswas for the respondent number 2 in the causal list.
Highly obliged.
Yes,
Obliged.
My lord, this is the regular bail application is a charge sheeted case, my lord.
Here also FOXO is there, service completed.
Service complete, my lord, to that effect during the course of trial, my lord, she filed a no objection also there, my lord. Lordship kindly have a look at page 28, my lord. That's why she did not, my lord, notice has already
No,
received, my
in
lord.
that case, we have to engage on amicus. Today, we will engage on amicus. We will hear the matter on next Tuesday or Wednesday.
Not Tuesday, my lord, some other, Wednesday or
Wednesday.
or Thursday.
Heard Mr. Barbuya, learned counsel for the accused, Mr. B. Sharma, learned additional PP for the state respondent. Mr. Sharma submits that in this matter, service is completed, but no one entered appearance for the respondent number 2. Accordingly, Mr. Who can be appointed?
Those who are having phone number, my lord, so that we can serve the copy.
All of them in the list has a phone number.
In the last occasion, at a corner.
Okay, Ankit today. Ankit today be appointed as amicus. This is shall reflect his name in the cause list and also furnish the relevant papers to him well in advance and list the matter on Wednesday.
Wait, please, your lordship. The regular bail application. Petitioner is in custody for 48 days, my lord. 48 days, my lord. Offense under section 51 of the Wildlife Protection Act, my lord.
What is the maximum punishment?
My lord, 60 days, my lord.
60 days.
60 days, my lord. Because of the Assam amendment, my lord, maximum punishment is 10 years.
It is a trial by session court?
Trial by sessions court, my lord. But the petitioner is 20 years old, my lord. He is a student. On the date on when he was apprehended by the police, my lord, he was traveling with his uncle. Your lordship will find it at page 11, my lord. And 18 kg of, my lord, pangolin skills were found in the vehicle. Vehicle belongs to his uncle. You can see page 11, my lord.
Yes, Mr. Sharma.
Yes, my lord.
Skin of pangolin, my lord, is covered from the person of the petitioner.
Yeah, so what is the stage of investigation?
Stage of investigation, my lord, FSL report not received. It was sent to my lord, or FSL report, my lord, that is not received. And my
But
lord,
you see, the 48 days already elapsed.
yes, it-
If you fail to submit the search sheet within the period of 60 days, then definitely he will be entitled to default bail.
my lord.
And what about the investigation? How many witnesses have been examined?
Actually, it's my lord, here is my lord only two, the two accused person, my lord. And my lord, investigation is on, my lord. And we are trying to procure the, my lord, FSL report. And as soon as FSL report, my lord, that's it.
No, whether the FSL report will improve your case. Granted that the report is positive, then also from where they got it?
In a vehicle, my lord.
They were traveling vehicle, my lord.
No, that's all right, but where they procured the same?
Yes, my lord. Like listed before your lordship. Yes,
Hmm.
ma'am.
Yes. Heard, Mr. S. Nawaz, learned counsel for the accused, and Mr. B. Sharma, learned special PP for the Forest Department. This application under section 483 of the BNSS 2023 is prepared by accused. Jibon Ahmed, who has been languishing in jail in connection with Lanka Reds, Lanka offense number LK stroke 15 of 2026-27 registered under section 9 stroke 39 stroke 44 stroke 49B stroke 49C stroke 50 stroke 51 of Wildlife Protection Act. Wildlife Protection Act. Since 28/6/2026. You come up. Hmm? Hmm. It is to be noted here that above noted case has been registered. On the basis of one report filed by Srimati Milu Balthari, Forester 1, Lanka Range, Lanka, on 20th/6/2026. The allegation against the accused in the aforementioned report offensive in the aforementioned case is that he was found in possession of pangolin scale in 2 gunny bags, which he carried in a vehicle, now weighing 18.5 kg, which he carried in a vehicle bearing registration number ES31F 7300 near Lonkatingal. Mr. Nawaz, learned counsel for the accused, submits that the accused was arrested on
On 19/6, my lord.
19/6/2026, and since then he has been languishing in jail. And that the statutory period of detention in this case is 60 days, and the accused has already been languishing in jail for 48 days, and that further custodial detention of the accused may not be warranted in the interest of investigation, and therefore he has contended to allow the petition. Per contra, Mr. Sharma, learned special PP for the press department, has produced the case diary before this court and submits that investigation is still going on and FSL report is still awaited. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on the record, and also produced the case diary produced before the court with the assistance of Mr. Sharma. In view of the materials collected so far in the case diary, and also in view of the progress of investigation as well as the period of detention of the accused in jail for last 48 days, this court is of the view that further custodial detention may not be warranted in the interest of investigation, and accordingly this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 20,000 with one security of like amount to the satisfaction of the learned session judge Huzai, the accused be enlarged on the CDB return.
On the play of that, my lord.
The learned legal aid counsel is absent. However, Mr. B. Sharma, learned additional PP, apprised this court that service report is still awaited. Accordingly, it is provided that recessal leads the matter on Tuesday. On that day, Mr. Sharma shall produce the service report before this court. Covered. Next.
I think 46 and 47.
And CB is the other side. Shall we, NCB is, my lord.
Bobby, inform him.
I will inform him at 2 months.
48.
Wait, there is a lawsuit. The last secretary lawsuit wanted to peruse the injury report, my lord. That is why one of the scan copy was called for.
In copy was called for,
That is.
and it has been received.
That is it.
Okay.
And got to have flag marked relevant pages. Admittedly, there is also now view on the right part of the victim. That has been big. But that's been given revealed from the statement of the eyewitnesses as well as the victims, that is the accused himself of.
As per the discharge certificate, there is no such grievous injuries, and he is behind the bar since last 75 days.
From of its cases made out lordship from the materials available in the court lordship. And thereafter lordship charges it not for failure under section 118-109 of PNS lordship. At the trestle of the trial proceeding, I'm vehemently objecting the application because sufficient ample materials is present with it. To prove its guilt under the that has been incorporated.
So as per this medical report, his injury is simple.
Not it. But there was two kind of lordship
Hmm.
injuries are there. One laceration was found on neck,
Hmm.
one abrasion. found-
Abrasion
As
on
far as
feet.
the neck is concerned, lordship, that with the down. Intention of 109 will be attracted lordship because that was injury was inflicted with a lateral weapon. That is
No, the
not-
trial court will consider at the time of framing of search. For how many days you were behind the bar?
75 days.
75 days.
Muslim may grant the bail, then he'll face the trial.
Let them, let the relevant witness be examined. Charges is already been found.
Pardon?
Charges is already been framed.
Framed.
Yes. At least lordship, because he has intention part lordship, at least. Hence he is-
Tension part, that is a matter of trial.
Yes. Injury was caused
trial
with a
court will
lateral
decide
weapon,
when-
that from the vital part of the body lordship, one neck. And
Hmm.
we have down. And from the.
Whether Dow is recovered, Dow is not recovered. Lordship will find in the CCA.
One by one. Please sit down.
Kindly come, as per my knowledge, friend's statement, submission is concerned, the dam was not recovered from the spot. To that effect, I would like to take your lordship to the statement of the accused person.
Hmm.
He has, after committing the offense, he has fled away from the spot and wrapped the dog with his shirt and pants and threw away in the river lodge. He himself stated what? The last page, Lord. I have flag marked. Statement of the-
Hmm. Maybe.
Not it only part, it case granting bail caution
Hmm.
at this stage.
Charge sheet is submitted
Yes. And
under section
109 and 118 subsection 2 of PNS.
118,
Yes, Lordship.
1 or 2.
2, Lordship.
But how this 118 2 will attract
Lordship. Subsection 1.
1?
Yes, Lordship.
1 is 3 years punishment.
Lordship. Approval clause 109 is also incorporated. Attempt to murder, Lordship. Where Lordship, conviction punishment is which may extend to 10 years, Lordship.
Maybe he will face the trial. You establish it by adducing evidence. Heard, Mr. I.H. Sarkia, learned counsel for the accused, Ms. S.S. Bora, learned additional PP for the state respondent. This application under section 483 of the BNSS 2023 is preferred by accused Kasinath Guragain, who has been languishing in jail hazard in connection with Jamaguri PS case number 47 of 2027 under section 118 within bracket 2 stroke 109 of BNS 2023 since 22nd of May 2026. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Krishna Bhattarai on 22nd of May 2026. The allegation, essence of allegation in the FIR against the present accused is that on 21st of May 2026, he assaulted Ganesh Bhattarai with a dao over his neck and caused serious injuries. Learned counsel for the accused submits that the accused was arrested on 22nd of May 2026 and since then he has been languishing in jail hazard for last 75 days. And that he will face the trial and will appear before the learned trial court regularly. And in the meantime, charge sheet has also been submitted. And under such circumstances, he is contented to allow this application. Per contra, Ms. Bora, learned additional PP, has vehemently opposed the petition. Referring to the statement of the witnesses from the scanned copy of the record received from the learned trial court, she submits that the accused have implicated the accused with the offense alleged. And though charge sheet has been submitted under section 118 within bracket subsection 1, yet the charge sheet is also submitted under section 109, where the maximum punishment prescribed is life. And therefore, she has opposed the petition. Whereas having heard the submission of learned counsel for both the parties, the court has carefully gone to the petition and the documents placed on record and also perused the scanned copy of the record. It appears that the medical report of the victim is available in the scanned copy of the record, and which indicates that the victim had sustained one lacerated injury over his neck and one abrasion over his feet, and the nature of the injury is simple in nature. Further, further in this matter, charge sheet has already been submitted, and the accused is languishing in jail hazard for last 75 days. Under the given facts and circumstances, further custodial detention of the accused seems to be not warranted here in this case. Since charge sheet has been submitted, the question of hampering investigation or tampering the witnesses also does not arise. Now trial will assert and the accused has to prepare his defense. Accordingly, the accused is allowed to go on bail of rupees 25,000 with one surety of like amount to the satisfaction of the learned session judge.
CCM Tezpur Sonitpur my lord.
Tezpur Sonitpur.
Here in this case, petitioner was granted interim bail, Lordship, and as per my instruction, he appeared before the investigating officer.
Lordship, Sarsit has been.
Sarsit. What is the number?
The white case number 16 of 2024. Dated 28/3/2026.
Heard Mr. Ahmed, learned counsel for the accused. And Ms. S.S. Bora, learned additional PP for the state respondent. This BNS bail application under section 482 of the BNS 2023 is prepared by applicant Ganesh Prasad alias Ganesh Sahu, who has been apprehending arrest in connection with Saptagram PS case number 17 of 2026 under section 132 on 296 stroke 351 within bracket 2, 317 within bracket 2, 317 within bracket 4, 318 within bracket 3, 3 within bracket 5 of BNS 2023 read with section 53 within bracket 1 within bracket A of Assam Excise Amendment Act. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by. Who lodged the FIR? Page number?
Deepak Gogoi, Lordship.
One Deepak Gogoi, SI of Police, Saptagram Prius on 21/2/2026. The allegation in the FIR against the applicant is that he stored illegal Indian-made foreign liquor in association with other co-accused and used to sell the same in Saptagram town. And the said illegal Indian-made foreign liquor were recovered from the possession of the co-accused. Mr. Ahmed, learned counsel for the applicant, submits that by order dated 27/3/2026, the applicant was granted the privilege of interim PRS bail. And thereafter, he had appeared before the IO and his statement is also recorded. And since he has been extending cooperation with the investigating agency, he has contended to make the interim order dated 27/3/2026 absolute in the same terms and conditions. Per contra, Ms. Bora, learned additional PP, submits that in the meantime, the investigating officer has completed the investigation and laid charge sheet against the accused, being charge sheet number
Number 16 of 2026.
since charge sheet has been submitted, this court is inclined to dispose of this application by directing the applicant to appear before the learned trial court and to apply for regular bail. And in the event of filing of such an application, the learned trial court shall consider the same in accordance with law. On or before 24th August. Till then, interim order dated
27/3/2026.
27/3/2026 stands extended.
Obliged.
It has been disposed of.
25.
Here also we see that petitioner is on interim and he, as per my instruction, he appeared before the investigating officer, Lordship.
Sarsit has been cut.
What is the number?
Sarsit number of 2026 dated 03/07/2026.
FIR is at page 11.
Heard, Mr. Ahmed, learned counsel for the applicant, and Ms. S.S. Bora, learned additional PP for the state respondent. Apprehending arrest in connection with Zhengrai Mukh PS case number 21 of 2026 under section 303 within bracket 2 317 within bracket 2 of BNS read with section 53(1)(a) stroke 54 of the Assam Excise Act. This pre-arrest bail application under section 482 of the BNS 2020 BNSS 2023 is preferred by accused. Vinod Pego for grant of the privilege of pre-arrest bail. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one. One Kulojyoti Roy. Who is Kulojyoti Roy?
He is the Lordship IC of Naya Bazar PP.
Inserts Noya Bazar PP Zengrai on 5/6/2026. The allegation in the FIR dated so and so against the present applicant is that he illegally possessed one Kingfisher strong beer, 650 ml into 70 bottle. Lord's whiskey, 750 ml into 12 bottles. McDowell number 1, 370 ml into 9 bottles. McDowell 1, 180 ml into 14 bottles. And Godfather beer, 500 ml to 20 can. Total 70.395 liter illegally. Mr. Ahmed, learned counsel for the applicant, submits that the applicant was granted the privilege of pre-arrest bail by the order dated 22nd of June 2026, and pursuant to the said order, the applicant had appeared before the IO and he has been cooperating with the investigating agency, and therefore Mr. Ahmed submits that the interim pre-arrest bail dated 22nd of June 2026 may be made absolute in the same terms and conditions. Ms. Bora, learned additional PP, submits that after completion of investigation, the IO has submitted search sheet in this matter, being search sheet number.
Charge sheet number.
By statute number 23/2026, dated 02/07/2026.
Since after completion of investigation, the IO has laid search sheet, this court is inclined to dispose of this application by directing the applicant to appear before the learned trial court and to apply for regular bail. And in the event of filing such an application, the learned trial court shall consider the same in accordance with law. On or before 24th. Till then, interim order dated 22nd of June 2025 is made absolute. No, extended.
Obliged.
Here also, precedent respect.
Okay, heard Mr.
A. Borpujari.
Learned counsel for the applicant, and Ms. S.S. Bora, learned additional PP for the state respondent. This application under section 482 of the BNSS 2023 is preferred by applicant Saurabh Das, who has been apprehending arrest in connection with Lotusel PS case number 38 of 2026 under section 109, 333, 351 within bracket 3 356 within bracket 2 stroke 75 within bracket 3 stroke 3 within bracket 5 of BNS 2023. The sense of allegation in the FIR dated so and so is that when the FIR was filed,
FIR dated 18/06/2020.
is that on 18/6/2026. The applicant along with one Himangsu Das has forcefully trespassed into her and into the house of the informant and attacked her husband. And when the husband of the informant managed to escape, then they threatened to commit rape upon her and to kill her children. To colon again, Kune laws course colon. On the basis of one FIR lost by one Srimati X name withheld. Learned counsel for the applicant submits that by order dated 7/7/2026, this court was pleased to grant the privilege of interim periodic bail to the applicant. And you have appeared before the IO?
My lord.
And pursuant to state order, the applicant had appeared before the IO and he has been cooperating with the investigating agency and therefore he is contented to make the interim order dated 7/7/2026 absolute in the same terms and conditions. Ms. Bora learned additional PP, however, submits that after completion of investigation, the IO has a late search sheet being search sheet number
By subject number 46/26, dated 21/7/26.
Since search sheet has been submitted in this matter, this court is inclined to dispose of this application by directing the applicant to appear before the learned trial court and to apply for regular bail. And in the event of filing such an application, the learned trial court shall consider the same in accordance with law. On or before? Till then, interim protection granted to the applicant by order dated 7/7/2026 stands extended.
May I please, your lordship? My lord, this matter being charge sheeted earlier occasion, your lordship was pleased to call for the, my lord, scan copy of the record. Man.
I have come for the only copy of the FIR in the group.
Even otherwise, my lord, I have stated pro additional affidavit, my lord. From the phase of the FIR, my lord, this kind of FIR is not maintainable, my lord, and it is legally barred, my lord.
How?
My lord, because, my lord, they are alleging that, my lord, to evade, my lord, legal proceeding, my lord, they have procured, my lord, one, my lord, fake birth certificate, my lord. So, my lord, if, my lord, this matter is already admittedly sub judice, my lord, then, my lord, in the meantime, my lord, they have also filed FIR, my lord, and case is already charge sheeted, my lord. And two petitioners before your lordship.
No, this entire record is not available before this court.
My lord,
the copy of FIR is received.
yes, sir. So, my lord, as charge sheeted, my lord, they will face trial, my lord, kindly, my lord, they may be allowed to go on bill. Other matter is regarding, my lord, documentary evidence, my lord, two birth certificate, which one is.
Mr. Borbuya, here the section is 6 of the POCSO Act is also there.
For 6 POCSO Act is not, London trial court also, my lord, said that, my lord, this is not true POCSO case, because, my lord, according to them, my lord, mother, my lord, petitioner number 2 show her, my lord, as a major, my lord, all these things are happened, my lord, she was married when she was minor. Therefore, my lord, POCSO is also.
Let
added.
the record come. Heard Mr. Borbhuya, learned counsel for the applicant, Mr. Porthakur, learned additional PP for the state respondent, and Mr. D.K. Agorwala, learned counsel for the respondent number 2. Mr. Porthakur submits that the TCR was called for, but the learned trial court has transmitted only the copy of FIR. And in order to adjudicate this application, entire record is necessary. And accordingly, he submits that the entire TCR may be called for. In view of the submission of learned counsel for both the parties, it is provided that registry shall call for the entire trial court record, scan copy of the trial court record, fixing the matter on 17.
Diploma.
Where page lordship? My lord, in this case, CD was called for me. The FIR is on the page number 15, madam.
Is there received? What is the stage of investigation?
Stage of investigation, my lord.
No, is there any material against the present applicant?
So yes, there are material, my lord. Earlier, 2 times he has approached before the London Session Court. Session Court has rejected twice rejected the application, my lord. His petition also is earlier in 2 other cases also, my lord. Your lordship may kindly close paragraph 22, page 10 of the petition, my lord. To last, report that, my lord. It is further stated that as on that 2 criminal proceeding being PRC case number 12, Dibrugarh page 5322,
Trial going on.
and in other 2 cases. Trial going on.
My history is bad, man. My background is bad, but I am not involved in this case. Madam. Only on suspicion, my name is made, madam. On the basis of the co-accused statement, my lord, police is searching, my lord.
And those 2 cases are also same nature with the present case?
No, no, no. There are some other issues.
Yes, in this present affair, my lord, that of that, of the affair reflects that, my lord. The person who beat away person is applicable. At this point of time, other persons to come.
There is matter is unknown person. After
Okay, okay, we will see the case diary.
Yes.
Porthakur, produce the case diary. We will pass the order after going through the case diary.
My lord.
For admission.
May I please, your lordships? My case is regarding release of my motorcycle, lordships. For interim custody, I filed the application before the court below. It was rejected by imperial order, lordships. Court observed that may be required for the purpose of investigation.
Your
Evidence stage, lordships.
your vehicle was seized in connection with NDPS case.
NDPS case, lordships.
Okay.
Even
Mr.
if,
Borbhuya, you see,
lordships,
the
even
vehicle was driven by you.
Yes.
There is a
motorcycle
decision of Supreme Court.
motorcycle is mine, lordships.
There is a decision of Supreme Court.
My lord,
Vishwajit De versus State of Assam.
Abhijit, the last occasions I lordship placed before your lordships, that judgment, lordship. Abhijit, their lordships, appeal number state of Assam.
Vishwajit De.
Yes, lordship. Lordships, kindly see paragraph 26.
No, you come to page number, paragraph number 29 directly.
My 26 is also important, lordship. May I read, lordships? That's why.
No, no, the ratio is 29.
Ratio is, lordship, but only then lordships also 38, lordships. Ratio is
Those seizure of drug substance from convenience can take place in number of situations, yet broadly speaking, there are four scenarios in which the drug or substance seized from a convenience. Firstly, where the owner of the vehicle is the person from whom the possession of contraband drugs substance is recovered. Secondly, where the contraband is recovered from the possession of the agent of the owner or like driver or cleaner hired by the owner. Thirdly, where the vehicle has been stolen by the accused and contraband is recovered from such stolen vehicle. Fourthly, where the contraband is seized, recovered from the third party occupant with or without possession of the vehicle without any allegation by the police that the contraband was stored and transported in the vehicle with the owners of knowledge and connivance. In the first two scenarios, the owner of the vehicle and or his agent would necessarily be arraigned as an accused. In the third and fourth scenario, the owner of the vehicle and or agent would not be arraigned as an accused. This court is of the view that criminal law has not to be applied in a vacuum, but to the facts of each case. Consequently, it is only in the first two scenarios that the vehicle may not be released on supervisory till reverse burden of proof is discharged by the accused owner.
Okay,
However,
okay,
in the
stop there.
third, my lord, kindly see paragraph 38, Lordship. 38, may I read, Lordships? The Supreme Court was, Lordship. This court is also of the view that
Paragraph number 30.
38, 39, and 40. I am reading, Lordship, may I read, Lordship?
Here,
This
no
court
38,
is
39 paragraph is there.
my one, please. My lord, kindly see. My lord, kindly. May I? Lordships, the paragraph is, one is showing 34 lordships. This court is also of the view that if the vehicle in the present case is allowed to be kept in the custody of police till the trial is over, it will serve no purpose. This court takes judicial notice that vehicles in police custody are stored in the open. Consequently, if the vehicle is not released during the trial, it will be wasted and suffering the vagaries of the weather. Its value will only reduce. On the contrary, if the vehicle in question is released, it would be beneficial to the owner, who would be able to earn his livelihood, to the bank financier, who would be repaid the loans disbursed by it, and to the society at large, as an additional vehicle would be available for transportation of goods. Consequently, the present criminal appeal is allowed with the direction of the trial court to release the vehicle in question in the interim on supervisory after preparing a video and still photographs of the vehicle and after obtaining all information documents necessary for identification of the vehicle, which shall be authenticated by the investigating officer, owner of the vehicle, and accused by the signing the same. Further, the appellant shall not sell or part with the ownership of the vehicle till conclusion of the trial, and shall furnish an undertaking to the trial court that he shall surrender the vehicle within 1 week of being so directed, and or pay the value of the vehicle determined according to income tax law on the date of his release, if so ultimately directed by the court. That's the direction, Lordship. It is open sky, Lordship.
So that direction
Lordship,
is
I
only in
love-
respect to
even
that case.
it can
Yes,
be
sir.
allowed.
Yes, sir.
Tested. Well, what purpose will serve, Lordship? Everything, any condition, I'm mainly using my dropping and lifting my child.
Where is the
Victim
guarantee
of
that you will
circumstances,
not use
Lordship.
the vehicle for committing
My
similar
motor,
kind of
I am the
offense?
owner, Lordship, lawful owner also.
Maybe.
Lordship, but here very clear, Lordship, Supreme Court's
But
Lordship judgment.
the paragraph number 29 is also
But
very clear.
finding is that, Lordship, that paragraph, finding is.
May I read my lord? Because
May-
why
No, no necessary. We will pass the order.
My lord, it is open sky, no, I am using my
Commercial
victim
quantity.
circumstances, and it has not found a handle of the vehicle. I was outside of the
Commercial quantity was recovered.
but lordships, ultimately vehicle is not required, lordships. What purpose will serve, lordships? Every day I will play.
The
My
purpose is
kindly be
stated in the
considered.
act itself.
My lord, my
Go
kindly
to
be
the
considered.
section 60.
By lord, but NDPS there is no one.
This matter relates to my lord, item, part third matter, item number 36. 37. My lord, I am extremely sorry, my lord. I am sorry for making convince to my friend. So lordship may kindly accommodate me for 3-4 days. I have talked to him, my lord, regarding the next date. He suggested both are agreeable, my lord, if the matter is fixed on 18th.
On?
18th. 18th, 1/8.
Okay. As agreed by learned advocates of both the parties, it is provided that registrar shall list the matter on 18th.
Of last time.
Pending item 46 and 47.
Maybe fixed on Monday or Tuesday, Lordship.
Already you have been granted accommodation.
Yes, Lordship, that's true, but he was already from the morning, but he was engaged in single bed. Now another delinquent bench is there at 2 o'clock, so he has some matter.
What is the matter there?
Yes, yes.
The key matter who decided.
No, monitoring bench regarding.
Pardon?
It's regarding, my lord, that MLA, MP criminal cases, my lord. There is a monitoring.
No, here also the liberty of the accused is involved.
Yes, Lordship, that's also true, Lordship.
Anyway, but
Monday.
Tomorrow.
tomorrow.
Already listed, my lord, Monday. Tuesday.
Okay. The pair being made by Ms. L. Devi, learned counsel appearing on behalf of Mr. R.K.D. Soduri, learned standing counsel, no, learned deputy solicitor general of India. This matter stands adjourned to be listed on Tuesday.
Item 14.
We have come against the order of framing charge, my lord. In this case, charge was framed under section 494 and 506 IPC, my lord. FIR case, your lordship will find that at page annexure 1, page 13 is the FIR. Initially, actually, it was a complaint filed under section 200, and it was forwarded to the magistrate, to the IO, for the investigating officer, local Thana for investigation, man. Page annexure 1, page 13, my lord. Relevant portion you will also find at page 14, my lord. With due respect, complainant beg to state that about 2.5 years back, above named accused and the complainant got married as per Hindu rites and rituals. After marriage, both of them stayed together as husband and wife at the house of the above named accused. After a few days, the accused started to physically, mentally torture the complainant, demanding dowry. Due to the above harassment, the complainant filed domestic violence case under section 498A against the accused person. Said case is still pending. Presently, the above named accused person, instead of getting divorced and separated from the complainant, got married to a person namely Bornali Rongpi, daughter of Beli Rongpi, mother Bhagya Rongpi, resident of Romi, Batamari, police station, Palasbari, Post Office, Romi district of Kamrup, 5 marriage, the decision number so and so. On 9/5/2019, the accused person with his newly married wife came to the residence of the complainant, situated at Karyani, and threatened the complainant for dissolution of marriage, and threatened the complainant to kill her faith if he doesn't give divorce to him. It be mentioned the accused person during the marriage of the complainant threatened her that he was going to marry other girls. Witnesses knew all about the incident, has seen it. Witness will prove the fact during cross-examination. I pray that kindly after taking evidence to ensure. So, on the basis of this complaint, my lord, case was registered as page 19 by Nagaon PS case number 13740 of 2019 under section 494, 294, 506, 34 IPC. Then, after completion of investigation, my the investigating officer submitted charge sheet. Your lordship will find at page 24 is the charge sheet. Charge sheet also there is page 24 relevant portion, my lord.
So this petition is for quashing the entire proceeding.
Yes, my lord.
Entire proceeding.
Yes. Now,
what is the ground?
Basically, ground, my lord, what is happening in this case? The proof of marriage. The proof of second marriage, there is no evidence to that effect, my lord. They relied on one photostat copy of a certificate that also the police never visited where the marriage took place. No evidence has been collected by police, my lord. Because what has happened in this case?
I have enclosed a copy of the statement of the witnesses recorded on 161.
No, that is a subject matter of trial.
No, I mean, there is no evidence to the effect. Which the question of trial comes, my lord. Absolutely, there is no evidence of second means. They cannot, what is not there, I have collected.
No, the certificate was collected.
Not collected, my lord. They never collected. A photoset copy was enclosed with the complaint. That is there. Nothing more than that.
No, would it not demonstrate prima facie case? What
That does
more is
demonstrate because
required
it is
at
a
the time
photoset
of-
copy without the signature, nothing is there, my lord.
Mhm.
Now, if and police never visited that place of occurrence where the marriage took place, my lord. No witnesses were examined, my lord. Absolutely, there is no evidence. Because in the case of 494, both the marriages have to prove, my lord. So far, the first marriage I admitted. But so far, the second marriage is concerned, that there has to be, they have to collect evidence, my lord, that it was legally proved, my lord. Because of the Hindu Marriage Act has been complied on, my lord. That is not there, my lord. And in fact, they have examined some witnesses, my lord. Their witnesses are from the, they have residents of this.
Okay, whether the record is available.
The 161 statement also I have enclosed, my lord,
Mhm.
along with my revision petition, my lord. Before lordship go to the 161 statement also. No witness have stated anything about that marriage, my lord. Only they are hard in here's evidence, my lord.
Oh, the case diary will be required here,
Yeah, case diary was not called for, my lord.
not called for.
May I please, Your Lordship?
Yes.
Lordship, in their complaint petition 424/19, they had made the secretary of Nag Shankar Mandir, the person who had given the marriage certificate as witness, Lordship, page 13 and 14. Yes,
13 and 14 of this.
their
Initial complaint case, my lord. But it was forwarded to the police station.
made a witness, the secretary, and moreover, Lordship, the police officer has visited the place of residence, place of occurrence, and in the charge sheet, they have stated that during the course of investigation, he visited the place of occurrence, draw a sketch map, and took complaint witnesses have enclosed one PO bag, 2 numbers of scissor lists, along with a second marriage certificate of the petitioner and the lady named Bornali Rockby. Now, Lordship have reviewed my petition, my affidavit, Lordship. Page 52, Lordship. Page 52 is the birth certificate of the male child born out of the wedlocks between the petitioner and the lady named Bornali Rockby, Lordship. It is issued by the government of Assam, Lordship. Page 52, and read. Lordship, page 53 is, page 54 is the vernacular version. Lordship, photo list of 2021, where Bornali Rockby Hoikia, Samir Na Ishan Sikya, Lordship. Which is issued by election officer Kolia Bird, Lordship.
Oh, but more evidence is required.
That evidence will not do, my lord, because factum of marriage has to be proved, my lord.
Hmm.
Lordship, this annexure.
No, that is a subject matter of trial.
But there is no, your lordship may kindly see, there is no evidence, my lord, how the marriage took place, where the marriage took place. No, the police never visited that temple, my lord. They have never, there was a priest who has solemnized the marriage. No one, nothing was examined, my lord.
Lordship, this all will be proved at the time of evidence, Lordship. They can say my humble submission
Because-
may be vacated, Lordship.
But factum of marriage, my lord, that is Supreme Court, a number of cases have revealed, as had categorically, both the marriage has been proved, my lord. In case of 494. For proving a charge under 494, the both the marriages have been
No,
proved.
no, unless they have been given a chance to prove the same, how can they will establish?
It should be a valid marriage for purpose of valid marriage, the customary rights at the prevailing at that point of time, whether they have been performed or not. So there is no evidence because police never collected those materials, man, during the course of investigation.
Okay, let the city come, we will see.
We don't know whether in the case that it is available or not.
Lordship, moreover, this petitioners has given number of series of cases, Lordship, and the respondent is deprived of even maintenance also, Lordship. Even the Honorable High Court in criminal petition also was directed to pay 50% amount, Lordship, but he has failed to do anything, any such thing, Lordship.
You go for execution or in this case, what we can do?
Moreover, this person always abscond, Lordship. My humble submission, Lordship, this stay order may be vacated since he is received, Lordship, because he is taking the benefit of this order of this court, Lordship. The respondent is suffering from last 3 to 4 years, Lordship, without any relief. This person is already remarried, had a son, Lordship.
Stay was granted on 19/12/2025.
25.
We never sought time, my lord. They file affidavit, it has come for admission, my today's first time.
Lordship, we have mentioned the case before, Lordship. Otherwise, this case was pending, Lordship.
So let the city come, we will finally hear and dispose.
As and dispose of, yes.
Lordship,
Pardon,
stay may be vacated till the city come, Lordship. Stay may
Pardon?
be vacated. Lordship, stay may be vacated till the city come, Lordship, because this person is taking benefit of.
Benefit of?
Instead of 1912, Lordship.
Benefit of?
Lordship,
What benefit he derived from this stay order?
because Lordship is not paying anything to this.
Paying anything, that is a different aspect. You go and file the application
different-
before
it is a
the
different case.
court. Yeah.
But this person, he has remarried. The respondent is suffering now.
Let the city come. Heard Mr. P. Kotoke, learned senior counsel assisted by learned counsel for the petitioner. And miss, your name please? A?
Proceed.
Learned counsel for the respondent number 2. Respondent number 2. Anybody for state? Mr. D. Sharma, learned additional PP for the state respondent. It appears that though LCR was called for and received, Yet, CD is not part of the said LCR. And to dispose of this petition, perusal of the CD is found to be necessary, and accordingly it is provided that rest shall fall for the scanned copy of the entire record and the case diary, fixing the matter on 20 August.
Made please, your lordship.
Hmm.
My lord, I file a
Service
CR case. my
completed
lord.
or not completed here?
I'm for the wife, my lord. That's what I know. And I'm for husband, my lord. Husband is an advocate. So what happened, my lord? I have a residence in Gauhati. In that residence, my lord, due to dispute, I am to leave that residence. And my car is in the custody of my wife. My motorcycle in the custody of my wife. And another thing is this, my lord, my books, law books, and my lord, my file. I practiced in Gauhati High Court for 20 years. All files, my lord, with original documents are kept in her custody. It is not allowed to hand over to me. That is why, my lord, I approached before the trial court with prayer that a search warrant may be issued and this vehicle may be handed over to me, and this, at least my books and the files, my lord, with original documents may be handed over to me. Otherwise, my lord, I cannot run my practice, and all the clients, my lord, pressurizing me that give our original document. Now, my lord, your lordship would be pleased. Specifically, I stated this in para 9, my lord. Para 9 at page.
So you have
Para 9,
challenged
your
the-
lordship would be pleased to see at page 22.
No, Mr. Sheikh, you were challenging the order dated 4/11/2025.
My lord. So, my lord, what the learned magistrate said that at this stage search warrant cannot be issued. Your lordship see the head of the petitioner, my lord. That car is under their custody. And nowadays, my lord, car is used for many purposes. Tomorrow, my lord, supposing the car faced an accident, some objectionable articles found in the car. I am the register owner, my lord. Car is not given to me. Then if they run the car, in future, what will happen to me? Every blame will come to me. And another thing is this, my lord, where is the necessity of my books, law books, by the wife? And your lordship would be pleased to see that I have stated in page 22, para 9, in detail. Para 9 may be seen, madam.
No, where is the impugn order?
Impugn order, madam. Impugn order, madam. At page 68, madam. 68 to 70. Page 70, further the court deems it not to be fit case to issue search warrant at this stage after perusal of the materials on record.
Where is the application seeking custody of the aforementioned vehicle or seeking
Page
recovery
9.
of the aforementioned vehicle?
Page 9.
Page?
Page 22, my lord, para 9. Para 9, your lordship would be pleased to see.
No, the application.
My lord, this is the CR case, my lord, I have filed.
No, you have filed the application before the trial court for issuing search warrant.
Yes, my lord, that
Where
is
is
the
that application?
prayer is there, my lord. Your lordship. Your lordship will turn to page 30.
Thirty is a part of the complaint.
CR case prayer, my lord. Prayer of the CR case. Three zero, my lord.
Where is the list of articles you have given
Malab,
there?
List
for
of
recovery?
articles is there. My lord, your lordship, it starts from page 33, my lord, certificate of registration.
No, list of articles.
My lord. My lord, regarding list of articles, my lord, I have given this registration certificate, my lord, of my vehicle. And I have stated in my para 9, my lord, what are the articles available there. But only thing is this, my lord, your lordship will consider regarding my vehicle. One vehicle and another is my books, my lord, law books and the files, my lord. I have elaborately stated, my lord, at para.
No, whether
There are-
your wife is not entitled to run the vehicle.
My lord, registration is in my name, my lord. How the
Maybe.
wife will run the vehicle?
Maybe.
My lord, I am the register owner. Responsibility is of mine. Responsibility
therefore,
of the
your
vehicle
wife
is of
cannot
mine.
run the vehicle.
Tomorrow, if some offense is committed regarding the vehicle, who will be responsible? Because dispute is going on between. If there is peace, my lord, no problem. Wife can drive. But thing is this, my lord, I am the register owner. Custody kept forcefully by wife. If it is run, my lord, tomorrow something may happen, and who will be responsible? I will be responsible. I will be sent to jail. And my humble submission before you, where is the business of my files and law books? Why search will not be made to hand over my books and my files? Every day when a client is pressuring me that there is a.
That's all right. But you have not mentioned the articles, list of articles.
My
here.
lord, regarding list of articles, my lord, if necessary, I will produce, my lord. But if your lordship satisfied, page 22, my lord.
No. On the basis of these statements, search warrant cannot be issued in a routine manner.
My lord. My lord, I have given the this registration, my lord, registration certificate of the vehicle. Page 33, my lord. Certificate of registration in my name.
That is there, but
Next, my lord, this, my lord, here your lordship will get this vehicle number, etc. everything.
Better you do one thing.
My lord,
You file an application before the trial court
my lord.
along with a list of articles.
List
And
of articles.
we direct the trial court to consider the same in accordance
Well,
with law. Yes?
Yes, my. But my learned senior.
No, no, and another thing is this, my lord. Regarding this, my lord, one thing. I have stated para 9 and 10 that these are the articles in the custody of the opposite party. They file a written statement, but unfortunately, they did not state anything regarding para 9 and 10. That
No,
documents
no.
is
In
nothing has been said.
complaint case, is there any provision for filing written statement?
My lord,
In complaint case, is there any provision of filing written statement?
may not file, my lord, but they file. Everything has been said, but 9 para and 10 is not said. That vehicle is in their custody, books in their custody. Not file, all right. But if file, they should state this, that what is the vehicle is in their custody or not. That is not said.
No, if they are
Well,
not bound to file their
all right, my
written
lord, I will file
statement.
the petition. I will file the petition. As your lordship observe that I will file the petition with list and the trial court will consider. I will
Yes.
file the list.
My lord, I don't understand, my lord. What is the meaning of custody, my lord? My lord, the petitioner, she is the wife of the, my lord, petitioner. The respondent is wife of the petitioner. And his son and daughter. My lord, they, my lord, run the car. And what is the meaning of custody, my lord? It is, the door is always open to come, my lord.
My lord.
Why he is
My lord,
sleeping?
it is interesting. I am to leave the profession due to pressure of my wife. I am practicing in Bilashipara.
He is sleeping
Because it is very dangerous.
with another lady.
Oh.
SAM.
S.A. Ahmed, learned counsel for the respondent. Number. Your respondent number.
One.
For respondent number 1.
That's deleted. Petition.
In this petition under section 442, read with section 438 of the BNSS 2023, the petitioner has challenged the order dated 4/11/2025 passed by the learned Judicial Magistrate First Class Kamrup M. Gauhati in CA case number 484 of 2023. It is to be noted here that by the impugned order dated so and so, the learned trial court has rejected the pair of the petitioner to issue search warrant for recovery of one car and also some law books which are kept
Bike also, my lord. Bio clock books
under
and
the
files,
custody of the respondent hearing. During the course of hearing, Mr. M.A. Sheikh, learned counsel for the petitioner, was asked whether the petitioner has filed any list of articles for recovery of which search warrant was applied for. Mr. Sheikh submits that no such list has been furnished along with the complaint petition. And in that view of the matter, this court is inclined to dispose of this petition by directing the petitioner herein to file an application before the learned trial court in the complaint case number 484 of 2024 by enclosing the list of articles which are required to be recovered by issuing search warrant. And on such petition being filed, the learned trial court shall consider the same in accordance with law.
Though, my lord, though this honorable court is not interfering with this order, my lord.
Pardon?
Tomorrow a technical question may arise that my order is not interfered with by the honorable high court. Then how I will pass another order?
Which one?
My lord, trial court, my lord, we file petition. An order is here. Denying
To the extent indicated
Some
above,
observation.
the impugned order is interfered with.
my lord.
May I please your lordship? Lordship, this is an statutory appeal, lordship, against order of conviction, lordship. 1 year conviction under section 323 of IPC and 342 of IPC, lordship.
Okay. Heard Mr. Bordoloi,
Keyboard, lordship.
learned counsel for the appellant, Ms. S.S. Bora, learned additional PP for the state respondent. Judgment and order.
Lordship, judgment dated, lordship.
Judgment dated 6/7/2026, passed by the learned session judge Vishwanath Sariali in session case number 8 of 2022. Is being challenged in this appeal under section 415 within bracket 2 of the BNSS 2023. It is to be noted here that by the impugned judgment dated so the learned trial court. This is the trial court. Trial court has convicted the appellant herein to suffer.
Three appellants.
Appellants herein to suffer simple imprisonment for a period of 1 year and also to pay a fine of ₹1,000 each with a default stipulation under section 123 IPC, and also sentence them to suffer imprisonment for a period of 1 year and also to pay a fine of ₹1,000 with default stipulation under section 342 IPC. And further directed that the substantive sentence shall run concurrently. So what is the punishment for 342?
1 year.
1 year. Where is the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment dated 6/7/2026. Admit, issue notice to the respondents, returnable in 4 weeks. State upon respondent number 2 be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued since Ms. Bora entered appearance and received notice for the respondent number 1. However, extra requisite copy of the memo of appeal will be furnished to her during the course of the day. Recessal call for the record from the learned trial court. Mr. Bordolo, learned counsel for the appellant, submits that since the period of sentence ordered to be suffered by the appellants is 1 year only, the said sentence may be suspended till disposal of this appeal. Accordingly, taking note of the submission of Mr. Bordolo, learned counsel for the appellant, and also considering the fact that the appeal has already been admitted for hearing and the record has been called for, the impugned order, the sentence so handed down by the impugned judgment and order, impugned judgment dated so and so stands suspended till disposal of this appeal.
Lordship.
And in view of the order passed in this criminal appeal, the interlocutory application filed by the applicant for suspension of the sentence stands closed.
Lordship.
Yes, the appellants are allowed to remain on previous bail.
Oblige, your lordship.
Hearing 36.
Something maybe some late on for
Some others. In the next.
Some other day.
Because I have to wait. How you will.
When?
Otherwise, I can start my lord.
No, when can it be taken up?
Lordship, it's convenient to me, because I leave it to lordship.
so maybe after some time or
After some time.
Some other day.
he's on late lordship.
Okay.
Next item.
39.
May be, Your Lordship. My lord, this is a transfer petition for transferring a complaint case, my lord, from Nagaland to Karimganj, now Sibumi.
Whether notice was issued?
Yes, notice issued. Notice issued, my lord.
Notice served?
Notice served, they have appeared, filed the affidavit also. Basically, the dispute is, my lord, civil dispute. Basically, it's a civil dispute of civil nature.
No, today they are absent.
They are absent.
Who appeared? PP? Oh, Nagaland?
Yes, Nagaland is there, and private respondent, they have got their advocate also.
Who appeared for the private respondent?
Private respondent, my lord.
Oh, why it is required to be transferred?
My lord, the petitioners are afraid of, my lord, appearing in that court, because the complainant is, my lord, the powerful person there, and they are under threat of their life, my lord. That is the reason.
Complainant is from Karimganj.
Yes, both of them, my lord, both the parties are originally from Karimganj. Actually, what happened, my lord, the accused persons, the petitioners hereof, were the employees of the complainant's shop, my lord. And there was some misappropriation of their fund of the shop during that period, whatever alleged, my lord. And out of that, my lord, a settlement took place at Karimganj district, my lord.
Now,
That
where the case is pending?
case is pending at Nagaland, my lord.
Nagaland, all right. There
Na-
are
Tuanchang.
many courts are there.
Yes.
In whose court? CJM court or session court or what
Is it-
court?
Is pending before, my lord, Judicial Magistrate First Class Tuanchang.
Tuensang.
Yes.
And the witnesses are from Tuensang district.
Or they are basically from Karimganj district.
But some of the witnesses are from that district also.
Because police has given FR. After that, on Naraji petition, my lord, this is on basis of depositions of the witnesses, this is notice has been issued.
No, if you have apprehension of your life at Tuensang, then it can be transferred to some other district.
Yes, it can be Dimapur also, my lord. Then it will be middle point, my lord. From Karimganj, they can come easily. That's communication.
Kobe, can you call the PP of Nagaland? This is KC. Okay, wait for some time.
That's what we.
May it please, your Lord.
Yes.
My Lord, this petition, I am seeking, my Lord, enforcement of an order framing charge, my Lord, under PCA,
Under
PCX, my Lord, section 7,
for causing.
my Lordship. Charges has been framed against me, my Lord.
No, against causing the entire proceeding or for particular order.
So far as, because there are more than one accused person in this present case, my Lord. So far as the proceeding against me, my Lord, I am seeking enforcement, my Lord,
Entire proceeding.
my Lordship.
Entire proceeding.
Framing of charge, my Lord, against framing of charge, I have come, my Lord. I am praying for discharge, my Lord. Now, what happened in this case, my Lord? Initially, one FIR was filed. Before I take your Lordship's attention.
Where is the impugn order?
Impugn order, my Lordship will find at page 90. May I read, my Lord? I am, my Lord, when this particular case was registered, I was acting as a additional superintendent of police in the district of Dorong. And I was discharging my duties thereon. Page number 90, annexure 5 is the, my Lord, order. May I read, my Lord?
Yes.
My Lordship. Third para, my Lord. The brief facts of the case is that on 12/6/2022, Sri Raju Turi, father of the victim girl, lodged an FIR before the officer in charge of Dhula Police Station, Darang, stating that about 2 years ago, accused Raju Nath had brought his 13-year-old minor daughter from his home with a promise to provide education to her and she would help in household work. Later on, accused Raju Nath kept his minor daughter as maidservant in the house of accused Krishna Kamal Borua. On 11/6/2022 at about 10 a.m., accused Raju Nath called him and asked him to come to Kharagpetia.
Mr. Das,
My Lordship.
okay, you come to the relevant portion of the order.
Relevant portion, my Lord. My Lord, page 91. This is the submission of the, my Lord, prosecution side. I have heard learned special public prosecutor on the point of framing of charge. The learned special PP submitted that there are ample materials to show that accused Utpal Bora, Rupam Phukon, Raj Mohan Ray tried to manipulate the investigation after receiving bribe amount and they did not investigate the case properly. And by suppressing materials evidence, they tried to safeguard the main accused Kamal Krishna Borua, who has been implicated under section so-and-so, read with section so-and-so POCSO. Now, my Lord, the last para of page 91. Here is the observation, my Lord. I have perused the statement of the witnesses recorded under section 161 CRPC and under section 164 CRPC and a charge sheet. It is found that the date of occurrence of the incident was on 11/6/2022, where a minor girl died in the rented house of Kamal Krishna Borua. The material on record reveals that the magistrate was called to the place of occurrence for inquest, but magistrate, without removing the cloths covering the dead body, conducted inquest, and the inquest report was prepared in Dhula PS. Proper photographs and videographs regarding ligature mark around the neck of the victim was not taken. And the most interesting part is that the victim girl was taken for postmortem without waiting for arrival of parents or guardian of the victim girl. The father of the victim girl came to hospital and saw dead body of his daughter after the postmortem was over. The additional superintendent of police, Dorong Sri Rupam Phukon, was present during that period. The additional SP Rupam Phukon did not direct for videography of postmortem examination. He did not take steps for immediate action against the prime accused Kamal Krishna Borua. On hearing audio conversation between accused Utpal Bora and the superintendent of police Dorong,
the accused Rajmohan Ray recorded in the mobile phone of accused Utpal Bora dated 26/2022 reveals that no proper step was taken to apprehend the culprit when there was a specific allegation in the Azahar dated 12/6/2022 about the rape and murder of the victim girl. The audio conversation between accused Utpal Bora and SP Dorong Rajmohan Ray on 30/6/2022 also reveals their soft corner towards the prime accused Kamal Krishna Borua, and they were waiting for surrender of the accused till that date. I found that accused Utpal Bora, Rajmohan Ray, and Rupam Fukan has violated. My name has been included, my lord. So what happened, my lord? Initially an FIR was filed by one Kamal Krishna Borua that his house, my lord, mate, she has committed suicide. Then, my lord, on the subsequent day, the father of the victim girl, he filed another FIR saying that, my lord, his daughter has been raped and murdered. And then, my lord, what happened? And that particular point of time, the OC is the Utpal Bora and the SP Dorong, my lord, they, my lord, OC was absent for 2 days. He was on leave, my lord. On third day, he joined. If my lordship would see, the entire investigation almost was completed, my lord, on the second, my lord, after the filing of the second FIR, and from the very, my lord, the materials that is available in this particular case, my lord, there is 164 statement wherein it is alleged that the OC has demanded, my lord, money, and they have given him money. That is illegal gratification, my lord. And the date, it is specifically stated 28/6, my lord, when the witness first met the OC. I am not for the OC, my lord. I am not for the SP also. I am for this additional SP, my lord. And if my lordship would see the order, my lord, in what manner he has been, my lord, the charges have been framed against him, my lord. Because subsequently, my lord, because for section 7, my lord, demand and acceptance sine qua non, my lord, to constitute such an offense. But in the entire case, if my lordship would see, my lord, there is absolutely no material against me, my lord. The allegation is against the OC, and audio conversation also, my lord, I'll place your lordship, my lord, that particular audio conversation. There is no mention about my name, my lord. So it is a clear case. At the very inception, my lord, charges would not have framed against me, my lord. Now page 93, my lord. Subsequently, my lord, page 93. May I read, my lord? Charge order only, my lord. The 161 CRPC statement and the 164 CRPC statement of the witnesses shows prima facie material about demand and acceptance of bribe by accused Utpal Bora in order to do favor to prime accused of criminal case Kamal Krishna Borua and settle the matter. I am not Utpal Bora, my lord. The statement of the witnesses under section 161 CRPC reveals that accused Utpal Bora received bribe amount, and he told the witnesses that he would share a portion of the bribe amount to SP Dorong and other senior officers, my lord. The material on record reveals that accused Utpal Bora made effort to show the cause of death of minor girl as suicide. As such, I found prima facie material against so and so against Utpal Bora. The role of Rupam Fukan in investigation of the case, right from the recovery of the dead body of the victim girl till the surrender of the prime accused Kamal Krishna Borua before the PS, and their nature of supervision in the investigation lead to sufficient material about his criminal conspiracy with accused Utpal Bora to do favor for accused Kamal Krishna Borua, and I find prima facie material against so and so under section so and so of IPC.
Yes.
So this is only, my lord, this is the only observation against me, my lord. Not doing, my lord, failure to do a particular, my lord, duty is a different aspect altogether, my lord. And a criminal case, my lord, is initiating a criminal case implicating a public servant, my lord, in a manner in this particular case has been done, my lord, is absolutely, my lord, unjustified.
What was your business to remain at the hospital at the time of conducting the postmortem report?
My lord, I am the additional SP, my lord. I was the additional SP,
And,
my lord.
why you have
It-
prevented the investigation taking its own course?
I never prevented, my lord.
That is the
That-
statement in the evidence of the witnesses.
No, my lord. I'll place, my lord, additional affidavit I have filed, placing on record the statement of the witnesses, my lord. The investigating officer 161 statement is there, my lord. I have never prevented anyone, my lord.
So you have been charged under section 7B.
7, my lord.
7B.
7B and my
Yeah.
lord, section 98 of my lord, Police, Assam Police Act, my lord.
Mm.
My lord, the very fact, my lord, that when the demand was made by the OC, when the acceptance was done by the OC,
Mm.
and the allegations in this case that I have not done my duty properly, my lord,
Mm.
it was prior to demand and acceptance. That particular aspect was never taken into consideration, my lord.
No, section 120B is there.
120B, there has to be some material for prior meeting of minds with
Mm.
either with the OC or SP, my lord. Absolutely, there
Mr.
is
Das,
nothing on record.
I have dealt with the bail application of some of the accused persons.
My lordship, this matter, my lord.
Yes, I had the occasion to go through the case diary at that point of time.
My lordship,
So more or less, I am acquainted with the facts
my lordship,
and also the statement of some of the witnesses.
my lordship. My case is very limited, my lord. The demand and acceptance. If my lordship is taking up the matter, my lord, then I'll
No,
submit. Otherwise,
Mr. Das, you say,
my lordship,
so far section 7B is concerned,
my lordship.
an undue advantage from any person is also sufficient to frame search
Yes, my lord.
for the improper as a reward for improper or dishonest performance of public duty,
My lordship,
or for forbearing to perform such
Perform
duty
such-
either by himself or by other public servant.
my lordship is absolutely correct. But in
So,
this particular
what was
case,
the business in interfering with the investigation then?
that my lord, if my lordship only see the 161 statement of the investigating officer of Dhula PS case number 114/2022, my lord,
Mm.
it is apparently clear, my lord. My role is I never prevented someone, my lord. Never prevented
No, that
any,
is your defense to be considered at the end of the trial.
my lordship. My submission
But
is
at the time of consideration of search only prima facie material.
prima facie material, my lord. My case is, in this particular case, there is nothing to, my lord, place that there was any demand made and any acceptance, my lord, done.
Maybe, but
Or,
undue
my lord,
favor.
undue favor, my lord, because that is what I was trying to place, my lord.
Mm.
The entire allegation took place on a date which is on 28 6, my lord, 2022.
Mm.
And whatever allegation against me is there, my lord,
Mm.
that I have not done some of my duties properly. That is what the allegation in this particular case is against me. Against this
Yes,
particular
the authority
officer.
has not acted upon the FIR lodged by the father of the victim.
Acted, registered, properly
And
investigated, my
subsequently?
lord. No, my lord, on the same date.
Mm.
Same date, my lord. I'll place.
And thereafter investigation was not carried
Investigation
out.
conducted, my lord. Postmortem done. My lord, the first first FIR,
Mm.
the informant has categorically stated the body was already brought down, and my lord, subsequently he informed the police station. It is the FIR, my lord, already brought down. Here, my lord, allegation is that, my lord, I have not taken the photograph or videograph while, my lord, bringing down the body.
Mm.
This kind of allegation, my lordship may kindly see whether that is possible, my lord, because before police went to the place of occurrence, my lord, the body was already brought down and that has been already informed, my lord. That is prior hand, my lord. When this particular case was informed, on the subsequent day, the father lost the Azahar, my lord. and the investigation was properly conducted, my lord. Subsequently, 2 days OC was on leave. He joined on the third day, my lord. This entire period investigation was on, my lord. I am the one who called for the CDR leading to the arrest of the accused. I am the one, yes, my lord, there is allegation that I kept the FIR for some time, and then SR. I have done the, I have,
No, therefore, this section 7B is there.
my lordship, that is what I am trying to submit, my lord. The series of incidences when the first that occurrence took place is the date of 28/6/2022, as per the, my lord, statement of the witnesses.
And,
164 statement.
You people have prepared the inquest report.
No, my lord.
And the magistrate put his signature at the police station.
Magistrate
On a
is
report
not an
prepared
accused
by
person
you
in this
people.
particular case, my lord. Magistrate is not an accused in this case,
No, he may
And-
not be, but he was arrested in that case.
my lordship. That is, my lord, on the
He
first
put
date.
his signature in the inquest report at the police station. The inquest report was prepared by you people.
Magistrate, my lord. Magistrate,
Magistrate only put his signature.
my lordship.
It was prepared by you people.
But, my lord, what I am, no, my lord, that is,
Yes,
that, my lordship, I have
yes.
to,
Therefore, the magistrate was arrested.
magistrate was, my lord, there are two cases in this case.
Mm.
The 114, that is Dhula PS,
Mm.
and this is special case, my lord.
Mm.
I am accused in this particular case.
Mm.
Charges against me, my lord. I have not discharged my duty properly, and, my lord, allegation of acceptance, demand and acceptance. My case is, my lord, if at the very that particular chapter, demand and acceptance, if at all, my lord, because that is the OC. My
Anyway,
lordship,
whether the 161 statements are available?
available, I have placed, my lord, by way of, my lord, affidavit. I have placed all the 161 statements. If my lordship permits me, today I'll place those statements. Otherwise, if my lordship is willing to take up this matter on any other date, my lord, then also I can, my lord, place it. But, my lord, 161 statement and 164 statement is very clear, my lord. Demand and acceptance on 28/6/2022. The case, my lord, registered on 12, first case registered on 11/6/2022, second case registered on 12/6/2022. So when, and there is absolutely no material at all, my lord, that I had any prior meeting of minds or I had any, my lord, conspiracy with the OC to take any illegal gratification, my lord. Under that circumstances, by taking carb of section 120B of CRPC, my lord, whether I can be, my lord, implicated in this particular case. Yes, there are clear in the materials that, my lord, demand and acceptance, so far the OC is concerned, my lord. But my involvement in this case, my lord, 161, I have gone through entire 161, my lord.
Whether the CD was called for here? Present.
Scan copy of the TCR called for, my lord. My lordship may kindly see. My petition only, I have annexed 164 statement of one, my lord, at 107 page number. My lord, one Tridip Deka, he categorically stated, my lord, that no monetary transaction was done with anybody except SI Utpal Bora. My affidavit, my lord. Page 51.
Mr. Hassan, whether the material so far collected against him is sufficient to frame charge under section 7B of the PC Act?
Object to my understanding, that the materials are concerned. There are enough materials. And this is not a case of isolated 7P. This is a case of criminal conspiracy. So each conspirator may not take it right personally. To my understanding, so far as the criminal conspiracy is concerned. Now, this is a case where the accused police officer, now the petitioner, he kept the things, certain things pending. Why I'm saying so? It was their admission. The special report case has to be raised in case of heinous offenses immediately. Now he kept the things pending for 12 days.
Pending for?
Severe, sorry, SR case. That is the special report case. That is the usual practice in the state of Assam. In order to consider certain heinous offenses, a special report case is normally registered, and it was entered in a classified index. And accordingly, the process is done with supervision of a senior police officer. Now, at that point of time, the petitioner was as an additional SP at one. In fact, he was the first gazetted officer from the police official, from the police department to visit the place of occurrence. Now, he was the person who was at the helm of affairs, and he treated the SR only on 24/6/2020. And this has come in the statement of LW34.
So it is not the allegation that I have not done the SR, my lord. I have done my duty, my lord.
Let him
My lord.
Now, I'm not saying that the SR was not done. My point is that when the SR should be considered, it is their own admission that the SR should be treated immediately. And what is the special report case? What is the significance of a special report case? So in case of heinous offenses, which is the usual practice, and that is why mechanism was there to treat it that way. The incident happened on 11/6/2020. SR was treated on 24/6/2020. Evidence says he kept the matter there. I don't know the reason why. Now,
Who is witness stated so?
LW34 at page 127 of interlocutory application 13K. Here's
Yeah, additional.
They have filed an additional affidavit. That is interlocutory application 13K. UPC 482 Mustafa. It is in their application as well. No dispute there.
Page number?
Page 127. UPC 482 Mustafa. That was arraigned as LW34. That is state witness 34. At page 126 of the interlocutory application.
Yes.
Your Worship may kindly come to paragraph, second paragraph. Dula PS case number 114/2022 was registered on 12/6/2022 and having received the FIR on the following day, that is on 13/6/2022, made entry in crime index register and put up the crime index register before the additional SP headquarters for getting it sealed by him. At that time, Reform was the additional SP headquarters. Here, the petitioner. He kept the FIR of case number 114, FIR of case number 114 of 2022 with him and released the crime index register. It was with the additional SP headquarters from 13/6/2022 when the register was given on 24/6/2022 to treat the case and process it. ABC Nazrul Islam immediately did the
as I was, that's all I have to say. So that is the delay that they have caused. Now, the another circumstance. Here in this case, very interestingly, LW 44 says no PC remand was taken. The accused was, the allegation is such that he committed rape and murder.
Page number?
LW 34, page number 139 and 152.
Anwar Hussain.
Anwar Hussain.
Yes.
The relevant portion is at second paragraph.
Yes.
Sorry. I'll start from the beginning if you're watching that also.
Yes. Yes.
To understand the case, but just a few lines below. On 10/6/22, it starts from 10/6/2022.
Mm.
Your Lordship got it.
Got it.
On 10/6/2022, OC Utpal Bora was on leave for 2 days. I was in charge. Around 10 a.m. on the following day, that is on 11/6/2022, Pansi Krishna Kapal Borua, son of Maneswar Borua, raised down from Mekano Shaburi PS, Tezpur, Sonipur, District Sonipur, Assam, pursued lost and Hazara with the PS in connection with an unnatural date, stating that he, along with his family, and made articulately was living in a rented house at Shapara. That in the morning that they state articulately, the daughter of Raju Turi, in absence of other persons, committed suicide by hanging herself inside the house, and that he lowered the dead body down and put it at the veranda of his house. Accordingly, SP Dharam, CI Tharupetia, Ashut Doctor, and the Magistrate of Tonga were informed of the matter. The additional SP told me that he would inform the SP Dharam and would come to the place of occurrence. CI Tharupetia Ashut Doctor had arrived at the station after registering Gauhati case number 8 of 2020. I, along with CI Tharupetia Ashut Doctor, SI Commissioner Gauhati and C41 Abdul Khalid for the place of occurrence. SI Commissioner Gauhati was deputed as the IO of the UP case. After arrival at the place of occurrence, the dead body of Arati Turi was lowered down and was kept in the ground floor by wrapping it with manhole fluid in compliance with the instruction of the CI. The dead body was lying supine at the veranda in the first floor of the rented house of Krishna Kamal Borua, and it was clad in an underwear and a frock. We took photographs with mobile phone. We did not do videography. We did not take women police with us. SI Promotional Kuldeep Gauhati seized the only with which the dead body was hanging. Compliance with the CI. The ceiling fan, table fan, bed seat, mattresses were not seized. Though Executive Magistrate Asirvad Najarita was present when the dead body was wrapped with mat and kept at an open space in the first floor, he did not see the dead body by opening it. He just saw it superficially and left for the police station, saying that he would write the annual report at the PS. The CI Promotional Kuldeep Gauhati and I came back to the police station. UBC Abdul Khalid put the dead body in dead body carrying van. After stopping the vehicle near the PS, he came to the PS for collecting papers. On our arrival at the PS, we found that the additional SP was sitting in the office room of the OC. The magistrate prepared inquest report in the office room of the OC and gave it to the SI Promotional Kuldeep Gauhati. Then he gave interest dead body challan and command certificate to UPC Abdul Khalid. Whereupon UPC Abdul Khalid took the dead body to Bombay Civil Hospital for post-mortem examination. After some time, the magistrate and additional SP, I should have been proceeded towards Mondo. I did not see when the additional SP headquarters visited the place of occurrence. After the post-mortem examination, the dead body was handed over to Raju Turi, the father of the deceased. Around 6 p.m. that day itself, Raju Turi brought the dead body by a public ambulance, and after stopping the ambulance in front of the PS, he met me and requested me for taking necessary arrangement for getting the dead body to his house without any problem, and accordingly, in compliance with the suggestion of additional SP headquarters, I informed the OCs, the PKs of the PS, and requested him to extend necessary assistance in this regard. The Raju Turi was questioned in connection with the unnatural death case and that day itself, though he said that he would not file any case and that he had no objection in connection with the incident. When the additional SP Dorong was informed of this, he told to release Krishna Kamal Borua, was yet detained at the PS. The Lordship may kindly take note of it. On the following day, that is on 12/6/2022, Raju Turi, the father of deceased Arati Turi, lodged an Azhar with the PS, and on the basis of the Azhar, I registered Tula PS case number 114 of 2022, and I myself took up the investigation. I visited the place of occurrence and issued notice under section 41A CRPC to the SSP, kept asking Krishna Kamal Guru at the PS. He did not appear, though the OC SI Utpal Bora joined his duties on 13/6/2020. He neither asked me anything about the UT case and regular cases, nor made any suggestion. Neither the SP additional SP headquarter nor any other relevant persons were giving any suggestion to me in supervising the case. In the evening on 36/2022, Krishna Kamal Baru was caught and brought from Hakirpara. So far as I know, the OC and additional SP headquarter were telling him to surrender. Who was the OC at that point of time? Utpal Bora, the prime accused, who took bribe, and who was the additional SP, the petitioner, were telling him to surrender. On the following day, when I asked the OC about the forwarding letter, he told me to write a simple forwarding letter and forward the accused to the court. And accordingly, I wrote a simple forwarding letter and forwarded accused Krishna Kamal Bora to Mumbai court, whereupon the court sent the accused to jail hazard. No PC remand was taken. Is it not a case where custodial interrogation is required at that point of time? Such a heinous offense.
The 161
I
statement
cannot
is there.
implicate anyone. I cannot implicate anyone at that point of time. So far as the accused police officials are concerned at that point of time, it's a very national case. But it was the duty of the police officials to conduct the investigation thoroughly and fair. Now, he was the person who called the CDR after a lapse of time. Your
Subsequently
Lordship, may
arrested.
kindly-
After calling of the CPR.
Your
Were
Lordship, may
arrested.
kindly, they have fairly mentioned at paragraph 16, at page 142. At page 142, that is the Anwar Hussain statement. At page 142.
Yes.
That is the last part. Being the investigator, that is the last paragraph, being the investigating officer in Dogla PS case number 114 of 2022 under section 7 I did not get any supervisory note from the additional SP headquarters. I did not get SR slip, that is the special report slip, WT, anything, etc. The SP, the additional SP, and the SI Karupeti and never supervised the case. That's all I have to say. This is a case where the Assam Police Act was also invoked. The violation of 47 FNC, which lead to punishment in section 98 of the Assam Police.
So only these are the materials against him.
No, there
Or
are
any other
materials
material?
also. LW 30 on if your lordship can kindly see the entire evidence of the court. The viscera was sent on the 44th day of the day of incident. Viscera was kept there in the mold. Such a heinous crime, such a heinous offense took place in Torong district when it went to the high corridors of power in Dispur. Then only the matter came to light, and accordingly, the police force came into action. On the 44th day, and that is not I am talking about what I am submitting, it is all there on record. LW 56 Abdul Jalil, what he says, on the 44th day of the incident, the viscera was sent. Now, this is a case where certain things have to be unfolded as by learned brother said that this I have not done, this I have done. This has to be unfolded to be fair enough without causing prejudice to the other side. This has to be unfolded at the course of the trial.
So he is the, my lord, Anwar Hussain, he is.
He is the person who had also shared the post-mortem report with the SSP authorities.
No, that is, my lord,
Now, how can
requisition was done by.
that rank, being an additional SP whose duty is to supervise the case to the best of his ability, he shared the report with the SSP authority.
Official communication, my lord, not on personnel front. SSB officials wrote, my lord, that to initiate inquiry against the accused, my lord. So I have supplied.
Lordship,
That is an official communication. It is not something personal, my lord.
Lordship, they wrote a letter. Now, who is SSP? We have to understand that. Now, Sasastra Sima Bal, they are the paramilitary force. They may not be knowing 13 nuances of the penal law. So it happens. They communicated it later that we want this type of these documents in order to verify from our side because the prime accused Krishna Kamal Burwa is an employee of SSB. Now that communication was there. Subsequent to that, the additional SP headquarters, violating all the procedures, he shared the information to the SSB authorities, and the IO had no knowledge. IO had categorically in his statement said, I don't have any knowledge about the sharing of the PM report to the SSB authorities.
If I didn't have done that, my lord, then they have said I have tried to screen the offender, my lord.
No, okay.
Either way, my lord. If I didn't have shared that document, because they are whatever the SSB are doing, they are doing it legally, my lord. Within the boundary of law, they have written a official communication seeking that they want to court-martial, my lord, him, the accused, and that is why I have supplied.
And my question is, are we not bounded by law? That since the investigation is going on, we are not concerned about the viscera part, we are not concerned about the severe part, we are not concerned about how the accused custodial interrogation is required. We are very much interested in sharing the information to the SSB authorities, that to sharing the PM report at the initial stage of investigation.
It is
Not at a later stage. Not at a later stage. I would have understand.
No. The question is, can you charge him for the offense under section 7B of the PC Act
No,
for sending the PM report to the SSB?
not that.
Then-
That is Assam Police Act. That is Assam Police Act which I am talking about. There is a violation of.
That is magistrate tribal, my
That
lord.
is the dereliction.
But I am facing trial at special court, my lord.
No, these are
today.
the circumstances what the trial court has recorded under the different charges. The trial court has recorded the entire findings based on certain circumstances as well as the other facts on record in correlation with the other accused persons. It is not, that is why I have submitted at the very outset that it is not an isolated case of 7B. It's a case of criminal conspiracy. So in criminal conspiracy, sometimes it happens that every time each offender need not be knowing what the other conspirator is executing it or doing it.
Let my learned brother submit only one point, my lord, on based on record. Any, my lord, material indicating, my lord, prior meeting of mine that is time and again as held by the Honorable Apex Court and numerous courts, my lord. Anything which that I had some communication either with TOC or the, my lord, SP, because it is the OC who demanded and accepted bribe as per the records, my lord. Anything, my lord, that I on the prior hand before 28/6 I had anything done, contacted, spoke to him, my lord, any communication or any material on record indicating section 120B, my lord. I'll withdraw my case, my lord.
Now, so far as the conspiracy is concerned, it has
Some material.
certain circumstances are there which can be inferred. Now, the circumstances.
Those
in
circumstances,
such a
my
way,
lord, let him
you
press.
are at the helm of affairs, you know, as a district police, second in charge after the SP, what needs to be done in that particular case. Now, are these circumstances not enough to rope in this trial
Okay,
along with the other officials?
Mr. Hassan, you please do one thing. You go through the record of the trial court
Yes.
and the statement of the witnesses, and you marked it. Who are the relevant witnesses here?
Yes, I can just give your lordship the witnesses, so far as the witnesses are concerned. I can give your lordship can take note of it. I've already prepared it. And the most important thing is that so far as the certain things which my learned brother has pointed out, these has to be unfolded during the course of the trial as per the Bazan last case. Now, again, going back to the American infrastructures case in 2001 of the Supreme Court. So this has to be unfolded only during the course of the trial.
No, Mr. Hassan, I don't think those decisions will help you because here he challenged the only search framing order.
Yes, sir. Not just charge
He is
framing
not
order.
before this court for quashing the entire proceeding.
No.
Charge framing, so far as his criminal proceedings are concerned, so far as the criminal proceedings against him is concerned, if the charge framing order goes naturally, the criminal proceedings will be.
Only
fought
to
against.
limited to my part is concerned, my
No, yeah.
And that time is also very relevant, my lord. When? 28, my lord.
No.
And,
Okay,
and this, my learned brother has read, my lord. This investigations had already been done prior to 28/6/2022, my lord. And OC was on leave for 2 days, my lord, when these investigations were going on. Where is the scope of any criminal conspiracy, my lord? First time demand and acceptance, my lord. First time demand was made itself on 28/6, my lord. And entire investigation was almost complete
Lordship,
before that.
What happens is.
It is not their case that I have not done my duty. It is their case that I have done something, but on a delayed, my lord. Some delay is there. SR, my lord, in fact, one of the witnesses categorically said it takes time to read all the SRs because this is not the only case where, my lord, SR is to be done, my lord.
No.
Hundreds of cases comes, my lord.
No.
And this is an exception, this case, why I am submitting, my lord. On the first day, an FIR was filed before our police station saying that she has committed suicide. Her father was, my lord, called for, asked to come to the Thana, my lord. He said, I will not file in any case, my lord. Subsequent day, he filed and it was registered, investigated properly, my lord. And 28, when OC joined his services, my lord, 28, he called one of the, my lord, witness, said there is an order for suited site. And that I can, my lord, interfere only by accepting bribe. That is what the material said, my lord. My lord, involvement is absolutely nowhere indicated, my lord, that I have demanded or accepted anything, my lord.
No, not necessary to demand and accept bribe. So far, the section B is
No,
concerned.
my 120B, my lord, that is what I am submitting, my lord. Let my learned friend point out
120B
that
also.
I had any criminal conspiracy to, my lord, with the OC, my lord, to demand and accept, my lord. So far as, my
No,
lord, 98 is concerned,
Mr. Das, to establish the charge under section 120B, direct evidence is not required.
circumstantial, my lord, any material, my lord, in the entire record, my lord. That is why I have come, my lord.
Lordship, we are
That
at
is
a
why I have
stage-
come.
Lordship, we are at a stage when prosecution witness 5 is being examined. Trial is in progress.
There are more than 30 witnesses.
Trial is in progress. Now, we have already started now charges are being framed and accordingly the prosecution evidence has already started.
And we are in officer to suffer, my lord.
And they have taken a plea that there was, it is their prerogative not to cross-examine a particular witness. They had requested the court to invoke the powers of the court so far as section 232, subsection 2 is concerned, deferment of the cross-examination till the examination of certain witnesses. That is their prerogative. They have taken that liberty. Now, the case is at the advanced stage. We have examined 5 witnesses. And none of the witnesses have turned hostile.
There are other accused person, my lord. Materials against other accused person.
I cannot go beyond the charts.
Okay, all right. You go through the record, you pointed out what are the circumstances to implicate him with the charge under 120B.
I can just, your lordship, the list is with me in a very rough way. But I can, if your lordship takes the entire things on record, then definitely I can submit it.
Yes, you can go through the record and you marked it in the statement of the witnesses also.
Yes, sir.
Relevant portion.
Relevant portions.
Okay. We'll
I'll
fix
also
the
place,
matter.
my lord, because, my lord, answering them, my lord, I also, my lord, pray that I may be allowed to, my lord, place specific, my lord, those.
Yes, you can.
My lordship, my lordship.
Yes.
My lordship. Deeply obliged.
Heard, Mr. M.K. Das, learned counsel for the petitioner, Mr. Hassan, learned special PP.
Special PP.
For the CBI. No, for the, for?
Special PP for this particular case, I'm appealing for CID.
CID, for CID. Heard in part, lays the matter on. Okay, sorted. 20. Okay. That's part heard.
20 can it be on 19th, your lordship? Tuesdays or Thursday, can it be on 27th then? 18th August.
My lordship. Deeply obliged.
Deeply obliged.
PM fixed at 3 PM, item 1 of production list.
I have obtained the certified copy, my lord. My lord, page 29 onwards, the dates are there, my lord. Page 29, my lord, 13 to 25. No, that is the first date, my lord. Thereafter, my lord, next page, my lord, P525. My lord, PM was on leave. So, my lord, another date was given, 21/6. 21/6, my lord. Again, court allowed, my lord, for 28/8. That is the second, my lord, adjournment. Then, my lord, third adjournment, my lord, on 28/8/25. Thereafter, my lord, 15/11/25. It was fixed, my lord, again on 15/11, PM was on leave. My lord, then at page 32, my lord, when the adjournment was allowed, my lord, the date was fixed on the date when there was the state assembly election. That is on 9/4/26. And then, my lord, the impugn order was
So you have taken 5 adjournments altogether.
total 5, my lord. And my lord, there were some medical grounds also, my lord. I was not well, my lord. If my lord sees, my lord, annexure.
How many adjournments you were entitled to?
My lord,
Well,
my-
there is specific
Yes,
provision
my lord.
for disposal of
Yes,
the
my lord.
case
Regarding
within
the
a period of
procedure, my
6
lord,
months.
under section 142, my lord, summary procedure is followed. If I
NI
may
Act.
take, my lord, to section 143 of the NI Act.
You have already taken 5 adjournments.
My lord, that is in summary procedure, my lord, that is not there, my lord. In summons trial, there is a limit that I will come, my lord. My lord, section 143. Section 143, my lord, says that notwithstanding anything contained in the CRPC, all offences in this chapter shall be tried by judicial magistrate of first class or by a metropolitan magistrate. The provisions of, my lord, 262 to 265 of the code shall apply, my lord. 262 to 265 is currently, my lord, 280, section 283 of BNSS. BNSS. So, my lord, in summary trial, there is no provision that on, my lord, cross-examination can be closed, my lord.
Maybe what is the purpose of making the case summary triable?
That is there, my lord. But the honorable court has followed the procedure of summons trial. Now, that is there, my lord, at page, my lord, section, if my lord takes section 346 of the BNSS Act, there the limits of adjournment is given, my lord, 346.
And where the period is fixed?
That is
6 months?
346, my lord.
Pardon?
My lord, section 346 of the BNSS, that is power to postpone or adjourn proceedings. There, my lord, will take, my lord, section 2, subclause D, my lord, starts with provided also that. My lord, section 346 of the BNSS. Subclause 2, my lord, in the next page, clause D. If my lord has got it, my lord, where a witness is present in court. But a party or his advocate is not present, or the party or his advocate, though present in court, is not ready to cross-examine or cross-examine the witness, the court may, if it thinks fit, record the statement of the witness and pass such order as it thinks fit, dispensing with the examination in chief or cross-examination of the witness. So, my lord, the statement of the witness has to be recorded. It cannot be closed, even if the procedure is followed. Although, my lord, my humble submission is that summary trial procedure is applicable. In the summary trial, my lord, there is no provision, my lord, for closing the cross-examination.
Okay, we'll see and pass the order.
My lord, medical grounds, my lord, are also there, my lord, because of.
Where is the medical document?
I have annexed, my lord,
We'll
page
see.
28.
Page?
Page
58.
28, my lord.
Okay, we'll see.
Since November, my lord, I am having that.
Okay.
Oblige.
Maybe. Lord,
So, Mr. Talukdar, any objection in transferring the case to Karimganj?
Yes, my lord, to that effect, I have filed affidavit and also I have filed an IA for punishing them for drawing a proceeding under perjury. My seriously trying to mislead and mislead the honorable court, my lord. Seriously. The thing is that, my lord, they being from my neighboring villages. I have a wholesale shop, grocery shop at Samatur of Nagaland from long man. I am a very old person running my shop. Suddenly, my mother became ill in my Karimganj, my native village. I had to rush immediately. So I kept three of those petitioners were there. I kept them please run for the time being. I went back after 15 days. Later, my mother also expired. In the meantime, they have took from wholesale shops of my teller, from Gulagat, from some other places, they have collected on wholesale basis. A large amount of money is taken and sold somewhere else, around 15, 16 lakhs.
No, we are not on the merit of the case.
My lord.
His contention is that at Twensang, he has the apprehension for his life.
Absolutely incorrect, my lord. How, my lord? I have kindly, my lord, take the affidavit I filed, my lord. On 2/2/24, my lord. Affidavit in opposition. Basically mentioned, what happened, my lord? After initially this incident took place in 2013. Thereafter, when I filed a case, after filing the case, when the police pursued them, they sit with me in my village. Yes,
So, is the search sheet is part of the record?
There is no charge sheet, FR was filed and thereafter.
this case, what happened? Thereafter an agreement is written executed between both the partners mutually in their own the residential house, my lord.
Page
Under
59.
their instance, my lord. And what happened? They did paid 50,000 at that point of time, and the remaining 2 lakhs to be paid in the next 1 or 2 months, kind of like this. What happened then after? They did not pay. They did not pay, rather, they claimed that they will not pay. Then, my lord, I again filed the case in 2016, my lord. After filing that case, the police insisted me to give the original agreement, copy of agreement, which I failed to give because it was in the third party's hand. It was kept in third party's hand. So those who are in the hands of the mediators.
Hmm.
It remained, so I could not. When they have filed this case, my lord, thereafter, my lord, I obtained the same. Then, my lord, till then they have filed the FR, police filed the FR. Then I filed Narazi petition. After filing Narazi petition, the court issued, my lord, the summon after summon after summon after summon for years, my lord. Then available warrants, many, my lord, several times. Then again, not available warrants, many a times, my lord. Well, even IGP level of communication is there also, from Nagaland to Assam. SP level, IGP level, police station level, they did not turn. Ultimately, when they feel that they cannot remain, whenever the police comes to their house, they went to Meghalaya. At Ladrim Bites, and police cannot go there.
So, okay, how many witnesses are cited in the search sheet?
My lord, here we have annexed the depositions of two
No,
witnesses.
no, not deposition form. Where is the search sheet?
My lord, is it
There
not
is not-
charge sheet, my lord?
there
Then
is-
it's fine. Then Narazi petition file,
Okay.
then their case.
Okay.
There is no trust.
Where is the Narazi petition?
Naraji, my lord, it's annexed at 3, my lord, page 32. This is the deposition directly, my lord. Page 32, annexed at 3, my lord.
Page 30.
32. The perusal of the my lord depositions indicates that the man that they are not for not having getting
Three
the
witnesses are examined.
yes. And they have stated, my lord, that as per agreement, they need 2 lakhs, my lord. It is not paid. That's why
No,
they
no,
have lost this
no,
FIR.
the question is whether the apprehension is real or it is just imaginary.
Only imaginary, my lord. Purely imaginary, my lord. And my lord, the statement they have made in the petition, my lord, all through are false, my lord. Not my lord, substantially false, my lord. And their own affidavit filed thereafter, when I filed the perjury appeal for, there they admitted everything, my lord. Yes, they are ready to pay to remaining payment. They are now ready to so all these things, my lord. But before that, my lord, they were totally
Okay,
missing.
let him justify his cause.
My lord, my humble submission is that, my lord, they have executed the agreement in Korimganj district, my lord. And for not payment by the accused persons, the petitioner hereof, my lord, they have lost the FIR, the complaint, Naraji complaint, my lord, in the court
No,
of
this is transfer petition.
Yes, Lordship. My humble submission is that, my lord, in the event it is transferred in the Dimapur, my lord, we would not have any objection to appear there, my lord. Because in the complainant is a, my lord, the powerful person there. That is our main contention, my lord. And
He's not a local person there.
he's
He is
almost
also
he is
from
local,
Korimganj.
almost he has become, my lord, local because he's staying there for years after years, my lord. Years after years. And he has got
So,
the
can it be in the nearby district?
yes, nearby
In,
district.
Zuneboto?
I not in that district, in other district.
My lord, what happened, my lord? The boys themselves, their own family members are there from long decades, my lord. They themselves were there. I annexed the school certificate of them. They have studied even there. And my lord, there his own brother had married a local lady in Tuensang, my lord, town. They are staying there. And Tuensang court is at a distance of about 60 kilometers from my shop, my lord. They need not touch my road, not to go by road, my road. They can go by the other main roads, my lord. Number one. Number one, I am an old man, my lord. Admittedly, I am an old man. I'm running the show. I cannot run, my lord, again. Number one. Number two, my lord, the witnesses.
No, no. What is the distance between Zuneboto and Tuensang?
My lord, from the, my lord, Samatur. It is Samatur, my lord. The place of occurrence is Samatur, my lord. There are 58 kilometers.
No, I am asking about distance between yes, madam, Juneboto and Tuensang.
May Lord kindly turn to page 16 of my application, my affidavit kindly, my Lord. The Lord facts are there, my Lord. That my Lord, the FU used to stay for a long many years there at Samatu itself. District Tuensang, Nagaland, even the petitioner one had gone to his school.
No,
even
no,
education from-
whether he is living there now.
At present, I do not know exact position, but their family business is there. They used to go stay there. They used to study there, my Lord, up to class 9 years studied there. In local, my Lord, Christian, I managed the document also, my Lord, certificate issued by the principal, my Lord. They were just staying there and they did not touch me. They can go by their own daughter is there, my Lord, staying there near the court, my Lord. And made a local lady, my Lord. Details I've given name, details, and I can given, my Lord. They are just trying to mislead, my Lord, and misguide me. And my Lord, not only
Yes, madam, what is the distance?
Kilometer is around 77.2 kilometer.
77.
Yes, Your Lordship.
Juneboto to Tuensang.
The place where this incident happened, like where the FIR is, the PS is, Shamakur is in between both the.
Okay.
So it is not this side also, that side also, it's somewhere in the center.
district code is, my Lord, 12 son. Code is 12.
It will fall under 27 district.
No, what would be the distance between Samatur and Juneboto? Or is there any other district headquarter there?
No.
Mukoksang will be
They, go further up.
okay.
Be like Pengsang will, sorry, Zenapoto will be the nearest.
Juneboto will be the nearest. But you tell me what is the distance between Samatur and this Juneboto?
Some witnesses are local people, my Lord, local
No, only 3 or 4 witnesses are there.
My Lord, my Lord, other witnesses are there, it is only under section 200 taken, my Lord. Other witnesses are there because matter was handled by some local native to solve the matter initially. It has not done so. Most of the witnesses are from there also, my Lord.
No. As per her version, it is
Lordship, rather it is showing distance from Chambatu to Zenapoto will be 133 kilometers.
133.
133 kilometers.
My Lord, before
It
going
will
to,
be further, right?
my Lord, kindly see the fact that, my Lord, when they file the petition before your Lordship, what they are saying that they have a common ancestral land. They were plowing it for many years. And because I have sold it to them, some amount remain unpaid. And now I have misleading everything. I file the case on the revenge on them, my Lord. This is their case, my Lord. But when
we are no, here we are not concerned with the merit of the case.
Well, look, kindly see the stand, the nature of the stand they have taken, how misleading and absolutely, my Lord, totally fabricating issues that basically leadership to get the order, my Lord. So, my Lord, I have also felt the perjury. When perjury being filed, then only they admitted the fact, my Lord. Yes, I have to pay 2 lakhs again. I will pay if the court orders. And earlier they have said, my Lord, they have purchased my land. Absolutely, my Lord. See their attitude and that, my Lord. And they are now trying to, on the basis of filing this case.
No. That is the business of the trial court. Trial court will look after the same, not by this.
My Lord, they are supposed to come before Lordship with clean hand, my Lord. They are trying to totally misleading facts and figures, my Lord. That should be considered by your Lordship. Only my prayer is that, my Lord. Had they came with the fresh clean hands, okay. Totally, my Lord, misleading and misguiding, absolutely fabricating stories, my Lord. So, my Lord, there is nothing, my Lord, to be, my Lord, examined to the point of their my Lord, security or else. They are more powerful there. Their own family members, I have mentioned names and details given, my Lord.
No, you could not say whether he is presently living there or not. Better you obtain instruction, we'll take it up on another date. You also obtain instruction of which place would be better. And which is the nearest
One thing
district headquarters.
can be done in the Lordship opinion, my Lord. In the last affidavit, they have filed to objection to perjury. They have admitted that And they say that we are ready to pay the remaining 2 lakhs if this will court permit.
No, we are not concerned with that.
No,
In this petition.
Pays, my lord, the acceptable amount, this can be closed there because for, my lord, cases of cheating can be, my lord, commanded by this report. If they really, my lord, wants.
Yes, you to obtain instruction in that regard.
It took some time from me, my lord, for this also. Well, they let us, that we can, my lord, amicable settle it, my lord. But he could not, my lord, protect with them perhaps.
He can obtain instruction.
Transfer to Tuinsang, it is easy. Lordship, the distance from the Shamata to Tuinsang is 55 to 56.
Yes.
So it's way nearer than Zinapoto.
Okay. Okay, then we may consider transferring the case.
It is in Tuinsang only, no? It is, now it is Tuinsang, and which is distance of 58 kilometers from me, from my shop. And they can go by yes, sir. If they were, they are also staying there, if someone else. But exactly, I have not taken the instruction, but they're also, they studied there, they're staying there, the family members are there, their uncles are there.
Okay, you obtain instruction of whether where he is presently residing. Where the petitioner is presently residing, you obtain instruction from your client. And he also obtain instruction of whether they are ready to settle
Yes.
the matter. But that settlement is not the subject matter of this petition. Heard Mr. Purkasal, learned counsel for the petition. Mr. Talukdar for the respondent number 2, Madam for the respondent number 1. List the matter on next week. 13. 13.
As part of.
As per 13. So you have no document to show that this Nirud Roy is the adopted son of Jalandhar Roy.
My lord, that documentary evidence, my lord, in this case is not, not there.
Not
But
there.
the oral statement, my lord, of the plaintiff PWR and PWD3, my lord, if it is considering the right perspective, my lord, that will, my lord, prove that yes, my lord, I am the nephew of the, my lord, the Jalandhar Rai, my lord. I am the nephew of the Jalandhar Rai, my lord. In that context also, my, because that has been admitted by PWD3, PWR also, the evidence of the High Court, the Honorable Trial Court and the Appellate Court also held that yes, but he is the nephew of the Jalandhar Rai. And Jalandhar Rai's name and his wife's name appeared in my exhibit 3 also.
Who is witness admitted that fact?
Yes, Lordship PWD3, if your Lordship looking
PWD3.
PWD3. my lord, PWD 3.
Where he admitted, which part?
My lord will find, I am defendant number 3, Roshik Roy, my lord. Because Roshik Roy is the son of the Indeshwar, Mohanto, my lord, under whom my uncle holding the tenancy right. Lordship will find, I am the defendant, just few lines, my lord. My father was the original owner of the suit land. Just 1, 2, 3, 4, 5 lines from bottom, my lord. My father has got ownership of entire land under the suit patta by way of purchase in an auction. Jolodhar Rai was our riot. Jolodhar Rai had no issue. Nirod Rai, the nephew of the Jolodhar Rai, stayed with him.
Which one?
My lord, PW3, my lord. Roshik
Which
Rai.
part?
My lord, just middle of the, my lord, his deposition. Cross.
Cross. Cross
Yes,
part.
deposition, my lord, lordship will find.
Cross examination.
Examination. Page number 8, my lord, of the translated copy of the deposition.
Page number 10.
8, my lord.
8.
8, lordship. PW3 Roshik Roy, my lord.
Yes, Rosik Roy.
I am the defendant number 3 to this suit. Defendant number 2 to 7 are my siblings. The suit land is covered by Dag number so and so, so and so, so and so. The suit land measure so and so. I do not remember other ducks. The suit land is situated in so and so, Mauja so and so. Now, my lord will find my father was the original owner of the suit land. My father had got ownership of the entire land under the suit patta by way of a purchase in an auction. Jolodhar Rai was our riot occupancy tenant. Jolodhar Rai had no issue. Nirod Rai, the nephew of the Jolodhar Rai, stayed with him. And my lord, if you worship, now my
merely they have acknowledged that he has
yes, my now lordship will find
become the tenant after the death of Jalandhar Roy. Does it mean that he is the adopted son?
my lord. In the my lord, that is lordship. On that my lord asked me what with the age, my lord. I have just noted, my lord. Yes, my lord will find, my lord, the if your lordship look into the evidence of PW1, Nirud Roy, my lord. Nirud Roy died in the year 2003. Thereafter, he was substituted.
You tell me whether the evidence of Rosik Roy,
my lord,
is sufficient to show that you are the son of adopted son of Jalandhar Roy. Where is the specific evidence?
My lord,
here he simply said that after the death of Jalandhar Roy,
my lord,
Sintamani Roy and you
huh,
inherited the right.
Yes, my lord. Now, my lord, the deposition of PW1, Nirud Roy, my lord. My lord, together, reading to PW1 and PW3, because PW was the Nirod Roy, my lord, who is the nephew of the Jalandhar Roy, my lord. And if your lordship look into Exhibit 3, that is Jamavandi, my lord, the name of Jalandhar Rai and Chintamani Rai has been recorded. Exhibit 3, my lord. It's not that, my lord, that they are, my uncle was not in a position, my auntie was not in a position of the land. The position derived from them. From that also, my lord, the source of the position is there. There is no denial that Jalandhar Rai and the Chintamani Rai name was not mutated in the Jamabandi Exhibit 3. Lordship may kindly look into the Exhibit 3, my lord, Jamabandi. That is being exhibited and proved. And my lord, it is also an admitted fact that, my lord, the Jalandhar Rai and the Chintamani Rai were issued.
Mr. Ghosh, you see,
lordship.
Even Nirud Roy also in his deposition nowhere stated that he is adopted by Jalandhar Roy.
Yeah.
Is there any statement?
My lord, he, not in many words, my lord, but if you look into the plaint.
Again,
Paragraph
you
4,
are coming to plain.
paragraph 4. Reading my lord.
No. Pleading cannot be accepted as proof.
Yes.
You have to substantiate the averment made in the plaint or in the written statement by adducing evidence.
Yes,
Where is
that
the
I know.
evidence? Where this PW1 Nirud Roy testified that he is the adopted son of Jalandhar Roy.
That, my lord, my paternal uncle did not have any child. Hence,
Hmm.
he bought me in
Hmm.
his house and raised me.
Does it mean that he has adopted him?
My lord, not in so many words, but
Huh?
if this evidence is when read in context of the pleading, my lord, as
No.
well the
No,
deposition of PW3. Because it is the case of old education, my lord, many things may not be remembered, my lord. He was,
No.
my lord, in
You were praying for right settled interest over the
not my lord, my tenancy right.
tenancy, right? Yes. So without any evidence, how can the court grant you the right? Declare your right.
In other word also, my lord, also, my lord, comes under the provision of the Hindu Succession Act, lordship. Because by section 8, and then, my lord, if your lordship look into section 9, section 15, my lord, because it is a that my Jalandhar Roy was possessing the land because his name was mutated. His wife's name was also there in the exhibit 3. And after the demise, my lord, and they are issueless, that is also been admitted. There is no, my lord, contradiction to that. Now your lordship will kindly see, just 15, my lord. Section 15 of the Hindu Succession Act, my lord.
Yes.
My lord, general rules of succession in the case of female Hindus, my lord will find. The property of the female Hindu dying intestate shall devolve according to the rules set out in section 16. Firstly, upon the sons and daughter, including the children of any predecessor son or and the husband. Secondly, upon the heirs of the husband. Because they do not have of their biological son, my lord. Of their son. So, my lord, B, secondly, upon the heirs of the husband. Heirs of the husband is the, my lord, the Nirod Rai.
No, in that case, whether he is the only son of his only son of his father.
Now, my lord, will likely see, my lord, 2B, section 2B. Any property inherited by the female Hindu from her husband or from her father-in-law shall devolve in absence of any son and daughter of the deceased, including so and so, not upon the other part, in order of specified therein upon the heirs of the husband. Now, my lord, lordship will find specified therein.
No. My question is he the only heirs of the husband of Sintamani Roy?
My lord, there is, my lord, no evidence to the contrary that he is not the evidence, because the other side did not file any written statement to counter the claim, my lord. Here, written statement only filed by only the person who has purchased the land from the, my lord, the legal heirs of the Indra Girishma Namashudra, my lord. There is no denial of that fact, my lord. Nowhere, my lord.
Mr. Soduri, are you not denying it?
Let them say they have denied that relationship.
See, even the witness of the plaintiff in cross-examination has pointed out that this the technique number 1 is not the has no legal right, was not related to Jalandhar Chintamani. So what has remains to us?
Which witness?
PW3 in the cross-examination stated.
PW3.
Raised Nirod Roy in his house. Nirod Roy was not related to Jalandhar Chintamani.
Which part?
This is a cross-examination of PW3 Lord.
Yes.
The cross-examination portion, the last page,
PW3.
PW3 lordship,
Hmm.
in the cross-examination portion of PW3, the Roshik Roy, in second page, lordship, third page,
Yes.
third page, middle. I don't know the relationship between Chintamani and Jaladhar, but Jaladhar Roy raised Nirodha Roy in his house. Nirodha Roy was not related to Jaladhar or Chintamani, but he used to live in Jaladhar's house. He is not related in any way adopted, so he is not in a position to claim any right over the land. And the Clarion Trial Court as well as the appellate court came to a finding the state of Assam was not a party because the relief was the decree was the decree was filed, the prayer was made in the decree with regard to the fact that for issuance of Khatia, if you are paying for the issuance of Khatia in the name of the plaintiff number 1, then the state of Assam is a necessary party. Even the state of Assam was not a party to the entire proceeding. The Clarion Trial Court specifically came to a finding that the plaintiff number 1 failed to establish the relationship with the Jalandhar Roy. And the second point is that the state of Assam was not a party to the proceeding, the Title 2. So in the view of the matter, there cannot be issued the name of the plaintiff number 1. So the plaintiff number 1 related to Jalandhar Roy, he has not been able to effect that very specific fact because he was asserting on the right of the adoption, but he was claiming the right over the land on the strength of adoption. But there is no document whatsoever in the evidence, no document proof to establish the fact that he was adopted. Even the evidence of PWC clearly specifies the fact that he was never been, that he has no relationship with the Jalandhar or Chintamani. So in that view of the matter, the Clarion Trial Court has the appellate with the concurrent finding of fact laws. And move to that lordship, this Nirodha Roy is the plaintiff number 1 with regard to finding that is substantially affecting the right of Nirodha Roy because the Nirodha Roy, this is claims by the present appellant that he had purchased the land to some extent from Nirodha Roy. Now Nirodha Roy can sell the land only when he is the bona fide legal heir of the original person, the Jalandhar Roy. Now, with regard to that particular issue, that whether he was adopted by Jalandhar Roy or not, that issue has attained finality because that issue he has never challenged for this only court. So this is substantially affecting the right of the plaintiff number 1 because they are independent person. Because the plaintiff number 2, although my learned friend has made a mention that if the decree is affecting, then the other party has the right to prepare an appeal. There is no bar to appeal, but the fact remains that with regard to that particular issue, whether is Jalandhar Roy, the Nirodha Roy, the plaintiff number 1, the legal heir of the Jalandhar Roy by way of adoption. That issue has written finality because the trial court has rejected that contention. Even when the appeal was pressed, that issue has been specifically determined by the licensed bar of the court. Now that issue, this cannot be the plaintiff number 2, who has no personal knowledge with regard to this aspect of the matter, he cannot challenge that particular issue. And that issue has a finality. But the person who is substantially being affected because of that particular finding, he is not assailing that order. So in that view of the matter, there is no very appeal order. Because of 13 appeal, there is no documentary evidence of the contention that Nirodha Roy is the adopted son of any person will come and say that I'm staying certain person by the adopted son of the other. It's not like that. You have to establish this particular fact and merely saying that the written statement, there is no denial. It is to say because it is for the police to establish the fact and how I am paying the right over the land. We have not been able to establish whether it has been specifically denied or not. It's not going to give any weightage or to the plaintiff. Also, has got it. This the PW3 has made a mention with regard to that fact.
Oh, yes, got it. Yes, Mr. Ghosh, anything to submit?
My lord, in this case, my lord, what my learned friend is says, the appeal has not been filed, my lord. Order 41 rule 4, my lord. Because here, my lord, we claim for a common relief. If your lordship look into the plaint, relief claim in the plaint. So we paid for a common relief, my lord, affecting both the.
No, maybe.
Yes.
If the trial court has held that
Yes, my lord.
you are not the adopted son,
Plaintiff number 1.
plaintiff number 1, not the adopted son of Jalandhar Roy,
Yes, my lord.
And appellate court has also affirmed the same,
Yes, my lord.
and the same has not been challenged. Then what can be done?
My lord, the one of the several, if your lordship look into the order 41 rule 4, may I read lordship? One of the several plaintiff defendant may obtain a reversal of the whole decree where it is proceed on a common ground to all. Yes. Why not? Because we applied for common ground, because we applied for common relief. We got declaration of judge right over the suit land by the plaintiff number 1 and 2. Judgment.
Can make a prayer for declaration of good trial only when the plaintiff number one.
Yes, so that is, it comes from them, him only, my lord, plaintiff one only.
One has relinquished his right, so far as he being the adopted son of the other person, the Jagadhara, then how he can put a challenge to that? Because it is in the knowledge of the plaintiff number one only, whether he is the adopted son of the Jagadhara or not. And that.
No, you cannot, Mr. Ghosh, you cannot challenge the same here.
Exactly, lordship.
So I am placing two judgment, lordship.
What judgment?
141, order 41, rule 4, my lord, where it has been clarified.
No, no, that finding, unless that person has challenged, you cannot challenge it.
Then it up to
And these are the decision of high courts.
Yes,
This court is not bound to follow this.
my lord, it rely on the decision of Supreme Court also there, my lord. 97, I just placed one judgment of Supreme Court also, my lord.
Let us do one thing. You furnish a copy to Mr. Chaudhary.
Yes.
Let him go.
Yeah.
And he has to reply on a different date.
Yes, yes.
We'll fix the matter on next Tuesday. Heard Mr. Mukherjee, Learned Counsel.
Vijay Ghosh.
No, Vijay Ghosh, Learned Counsel for the appellant, Mr. Chaudhary for the respondent. Heard in part, lays the matter on Tuesday for final consideration. You furnish a copy to him.
Okay. Yeah, please, your lordship. Lordship, criminal appeal number 75 of 26 and along with IA 174 of 2026. Today was fixed for the hearing of the IA.
You are amicus here?
No.
No, engage counsel.
Yes.
Okay. So you have been convicted under section
302.
307.
Yes, lordship, for a term of simple imprisonment for a term of 5 years along with a fine of rupees 10,000.
You are undergoing sentence or you have been granted bail?
Yes, since the passing of the judgment on 12/11/2025, I'm undergoing the sentence. Lordship, in the order in page number 13, it was also specifically mentioned that the accused had suffered a stroke earlier and his health condition was not fit. And later also, lordship, the accused's health condition is very bad and he is behind the bar. Medical documents are annexed, your lordship. Medical documents are in page number 65.
Page number
Medical documents are in page number 55.
55.
65, sorry, 65. 65 onwards. 65 onwards.
The trial court record.
Beg your pardon?
Trial court record.
Yes, Your Lordship. No, in my record, Your Lordship.
Page number 65.
65 of the IA.
I. Who is Raju De?
Beg your pardon?
Who is Raju De?
Razudi is the convict, Your Lordship.
Convict.
Convict.
And he is suffering from?
Stroke, Your Lordship. Razu De, alias Razu Devnath, he suffered a severe stroke. And Your Lordship, the same has been mentioned in page number 13, where the order is annexed. Order of the trial court is annexed. Your Lordship, in page number 13, paragraph 5. It was clearly mentioned about his stroke, Your Lordship, in page number 13 of the
No,
IA.
maybe. And presently he is undergoing sentence.
Yes, Your Lordship.
And the facility of treatment is available at Diffu jail also.
Yes, but Diffu is a small place, therefore
Maybe
in jail the treatment is
Diffu, there is a medical college there.
Yes, Your Lordship.
Medical college there.
But in jail, Your Lordship, the treatments are not better. In Gauhati also, in jail, treatments are not better.
No, in jail may not be, but if necessary, he can be shifted to the medical college also.
But his condition, Your Lordship, is so severe that he may die at any time, Your Lordship.
Mr. Borthakur, can you obtain instruction regarding the status of health?
Your Lordship may kindly come to the judgment or Your Lordship page 43 of the regarding at the time of otherwise the evidence of PW 2 is the
No. Borthakur, her condition, her contention is that
point of regarding all these mitigating circumstances, punishment was only given 5 years, that is,
No, Borthakur.
yes, at the time of provide the accused is medically unwell and he is completely bedridden and suffered from stroke. That is at the time of giving the judgment, that is in fact recorded by this
Yes.
mitigating circumstances comparing all this.
No. What is the status of as of now?
Yes, I can get it.
You can obtain instruction. If he is so serious, then we can enlarge him on bail for treatment.
Trial took place about almost 26 years. Incident is of 99.
Yes.
And
26 years.
26 years, madam.
No, at that time, the judiciary was not separated there.
Yes,
It was pending before the executive court. Heard means
S.Z. Hayat.
learned counsel for the applicant in IA number 174 of 2026. The learned counsel for the applicant submits that the applicant suffered stroke before he was convicted, and that at present he is undergoing sentence in Diffu jail, and his condition is so serious that unless he is shifted to a advanced hospital, advanced medical care center, stroke hospital, he will die at any moment. Taking note of the and as such, he has contended to enlarge the convict on bail for better medical treatment. Having considered the submission of Ms. Hayat, learned counsel for the applicant, Mr. Borthakur, learned additional PP, is directed to obtain up-to-date status report of the convict and apprise this court tomorrow at 2 p.m. You can verbally obtain instruction also if possible.
Yes.
Highly obliged.